Good evening. Welcome to the August 29, 2019 meeting of the Zoning Hearing Board. I invite you to join us in the Pledge of Allegiance. Thank you. One pleasant administrative matter before we get started. I'd like to welcome to the board Jamie Bright Foreman, who has been named to the second alternate member position by the Board of Commissioners just a bit earlier this month. We welcome her. We look forward to working with her, and we're throwing you in the deep end on your first meeting. You'll be voting with us tonight, so thank you. All right. The agenda, appeal number 3045, the appellant, DJB Properties, property located 131 through 133 Garrett Avenue, appealing the zoning officer's enforcement notice dated June 6, 2019, regarding a structure that exceeds the maximum allowable building height. Appellant requests a variance from Code Section 280 49.5 and 280 49.6A to A1 relating to the manner of measure as well as the maximum height limitation of 30 feet. Appellant proposes to construct a twin dwelling which has a maximum height of 36 feet 9 inches when measured pursuant to the aforementioned code sections. In the alternative, the appellant requests that the Zoning Hearing Board make a determination that appellant 1, has acquired a vested right in the permits that were issued by the Township. 2, has acquired the requested zoning relief through variance by estoppel. 3, has acquired the requested zoning relief through equitable estoppel. And 4, has acquired the requested zoning relief through any other legal or equitable principles that are developed during the hearing on this matter. Counsel?
Doing open arguments?
We're not going to be doing opening arguments. Let's just get right to your case. I think we're going to be spending some time here this evening. So
I guess then procedurally, the question I have is that
We go first.
correct. That's what I was going to bring up.
We go first because we issue the enforcement notice.
that's right. Okay.
616.1 of the MPC. Township goes first. When you issue an enforcement notice, the municipality has the burden of proof to start off with testimony and evidence in support of that. So we're prepared to do that. I do have one other procedural issue. I know there's some residents, neighbors here that have an interest in becoming parties. So before I get going with the Township's first witness, that might be something I think the board should address. Yes. John Rice here for Radnor Township.
One of the items that we discussed before we convened the session was that very issue of parties, additional parties in interest. I would propose that anyone here who wishes to become a party in interest to this matter, and what that means is something a bit further than simply coming up and offering testimony and then sitting back down. What a party in interest to this matter would gain by becoming a party is to preserve the right to appeal any decision that the Zoning Hearing Board might reach this evening. So, former Chair Martin will put a pad on the back. If you wish to become a party in interest to this proceeding, I would ask that you write your name, your address, a contact number at which we can get you, maybe an email address, and that will be sufficient. What that also, though, means is, I'll skip that other part. Mr. Rice.
Mr. Chairman, just one other suggestion, since I think it's appropriate to have the people that want to become parties put it on the record, in case this gentleman wants to challenge that. Just signing in on a sign-in sheet, I don't think is really sufficient to get it into the record. It ought to be in the record, the reason why, what their interest is. I know if a couple of the residents mentioned that to me prior. So if
And that's fine, Mr. Rice, and also gives parties the ability to question whether they're
Sure.
appropriate parties.
Sure. So do you want to take that up with, because I know there's at least two people back there that have that interest.
Okay, anyone who wishes to become a party to this proceeding, please come up now. Please state your name, your address, your interest in the proceeding, and one of the other two parties may have questions for you as part of your request to become a party.
And I would add, also put your name on the sheet.
And to clarify, Mr. Chair, is this when you want them to share their perspective on the application, or we're just?
No, we are simply identifying the parties to the proceeding at this point.
Okay,
So this is not testimony, this is merely name, just a very, address, very quick summary of why you wish to become a party to the proceeding, and then we'll take it from there.
okay. My name is Patty Barker, B as in Bravo, A-R-K-E-R. I live on, at 920 Lewis Lane, Rosemont, Pennsylvania, Garrett Hill. I had a letter I was hoping to read to you.
This is not the time for that?
Okay, fine, so I am the former chair of the Garrett Hill Coalition, and as such, I'm standing for the residents of Garrett Hill.
Well, I'll let others ask whether that's appropriate, but where do you live in proximity to the property in question?
This property is on the north side of Conestoga. I live on the south side, about a quarter of a mile from where it is, approximately.
I have no objection.
Counsel? No objection. Okay, thank you.
Okay, thanks.
Anyone else care to join?
Good evening, members of the Radnor Township Zoning Board. My name is Rick Barker, and I live at 920 Lewis Lane in Garrett Hill. I respectfully request that I be allowed to become a party to this hearing. I served as chair of the Board of Commissioners appointed Garrett Hill Steering Committee, tasked with overseeing the rezoning of a section of Garrett Hill. I stand for those who created the Garrett Hill Zoning District Code, the hundreds of citizen participants, the planner, the architect, as well as the Radnor Township staff. The 2.5-year-long process
Okay,
was
thank you, Mr. Barker. Thank you. Any objection? Any objection? Thank you very much. Well, I'm sure you'll have another opportunity to speak.
Thank you.
Good evening.
Good evening. I'm Nancy Linemond. I live at 149 Lowry's Lane.
Could you spell that, please?
Sure, it's Leinwand.
Thank you.
Since June 1986, my property is located 2 blocks from 131, 133, but, you know, as the crow flies. I served on the steering committee that developed the Garrett Hill zoning district ordinances, and subsequently I served on the Garrett Hill implementation committee that aimed to guide the Garrett Hill master plan process. I would like to become party to this hearing.
Okay, great. Any objection?
No objection.
Hello, my name is Aude Robinson. I live at 51. Sorry.
You got to spell that, both names.
Aude, A-U-D-E, Robinson, R-O-B-I-N-S-O-N. I live at 51 Garrett Avenue. I am adjacent to the Emerald Tunnel Park, which has already been quite a challenge for us.
Which
I-
side of the bridge are you on from the subject property? Are you
I'm
on the
west-
Lancaster Avenue side of the bridge, or?
I am on the Lancaster side of
Thank
the
you.
bridge. Next to me is a property being built at 49 Garrett Avenue, which is ginormous.
Okay.
And I have
That's
concerns.
not why we're here.
Okay, fine.
Any objection?
No objection.
Okay, thank you very much.
Thank you.
Anyone else?
Inger, I-N-G-E-R, Amanulla, Amanullah. I've done that many times. 104 Garrett Avenue on the same side of the bridge as the house. And I'd
And
like
your
to
connection?
be a party of this.
You're,
I'm not an expert. I haven't been on any committees.
Okay.
I just live there.
great. Objections?
My name is Dee Delaney. I live at 229 Williams Road. I've been very involved with the community on different occasions, and I feel deeply invested in what our community is and what it becomes. So I would like to be a party to this.
Any objection?
No objection.
Thank you very much.
Okay, thank you.
Hi, my name is Lauren Wiegand. I live at 229 Williams Road, Weigand. Lauren is my first name. And I was also a member of the Garrett Hill Coalition. I was the treasurer and involved in the community.
Any objection?
No objection.
Okay, thank you. Okay, if there's no one else wishing to join as a party, Solicitor Rice?
Mr. Chairman, if I could have Mr. Kachansky sit up here because we have one handheld, there's a mic over there, and we have a live mic up there. He's my first witness. I'd like to call him to have him.
That's fine.
Kevin Kachansky. Mr. Kachansky, what's your position with Radnor Township?
I'm the Director of Community Development for Radnor Township.
And what does the Director of Community Development do in Radnor Township?
I'm responsible for the issuance of building permits, zoning regulations, health code, rental properties, property maintenance.
And how long have you been doing that in Radnor Township?
Since December of 2011, so about 8 years.
Familiar with 131 and 133 Garrett and that project?
I am.
And are you familiar what various permits have been issued and what process that project has gone through?
Yes, from the early on Planning Commission meetings as it was going through the subdivision land development process, through the issuance of the building permit, and ultimately to the issuance of the enforcement notice, which brings us here tonight.
Okay. And do you attend the Planning Commission meetings?
I do on occasion, yes.
The Chairman, if I could just mark Mr. Kachansky's enforcement notice, it's dated June 6, 2019. It's
T1?
T for Ken. I have other copies. Everybody probably has copies of this.
You want this back?
If not, there's extra copies here. Mr. Kachansky, could you identify what's been marked as T1 for me?
T1 is a zoning enforcement notice dated June 6, 2019, that I issued to DJB Properties LLC, the property owner of record for 131. There was another one issued for 133, Garrett Avenue.
Could you just walk us through why you issued this and what is the specific violation that is referenced in here?
Earlier in the year, it was February, I believe it was the 23rd, the township received an email from a concerned resident inquiring about the height of the building that was under construction. That following Monday, the 25th, I reviewed the information and the plans and determined that the building was indeed larger than what the zoning allows. Several months later, after negotiations or settlements talks with the property owner to see if we can come with some sort of resolution to address the zoning violation, We were not making any progress, and ultimately I needed to move this along, and the only way of doing that was to issue a zoning enforcement notice.
So when did you first become aware of the 6.5 foot, more or less, height difference?
Not specifically the actual height variance, the dimensional aspect of it, but that it was larger. It was February 23rd was the email came in, so the 24th or the 25th when it was forwarded to me by the township manager.
And did you notify anybody from DJB Properties at the time?
It was either the 25th or the 26th of February. I called Mr. Brasso, who is the property owner under DJB Properties, and informed him of the potential issue and asked him to take a look at it.
And what did he say?
He indicated he would look into it and get back to me at that point.
Did he get back to you?
He did not. I followed up with an email 2 days later on the 27th, inquiring about if he had a chance to talk to his architect about the issue. And I did receive a response later that day from him indicating that he had a meeting scheduled later in the week with his attorney and with his architect to look over the matter, and he would get back to me after that.
And court reporter to Mark, email dated February 27th, 2019. Was Pete too. What is T2?
T2 is the email that I referenced that I sent to Mr. Brasso, asking him if he had a chance to follow up with his architect regarding the roof height that we had discussed a day or two prior.
What was the response from him?
I believe it was something to the effect of he had a meeting later on in that week with his architect and his attorney to review the issue.
Did he ever come back to you with any kind of a remediation plan?
Not to me personally, no.
In February 2019, were you out on the property at the time?
I did stop out. After looking at the building permit file, it was a Monday. We had a board meeting that Monday night, a Board of Commissioners meeting. So after the meeting, I did stop out to verify the status of the project and made some visual observations at that point in time.
Take any photographs?
I did.
Our court reporter marked this as T3. Mr. Kachansky, what does T3 depict?
T3 depicts a picture that I took from Garrett Avenue, dated February 25th, 2019, at 8:50 in the evening. It depicts the building under construction. At that point, my observations were that the roof had been framed in and sheathed at that point. I do not recall if there was anything further beyond the roof sheathing, but there was Tyvek's house wrap on the side of the sheathing.
Okay. And the building you're talking about is the one on the right, is on the right side of the photograph, correct?
Correct. It is on the right side of the photograph.
Mr. Rice, I'm going to have to ask, can you consider conducting questioning from there so that the remainder of the parties, as well as our vast television audience, can see the pictures? All right. And if we could ask whoever's handling the screen in the back, thank you very much.
So, Mr. Kachansky, T3, the building on the right side of the photograph, that's 131, or is that 133?
I believe that is 131.
Okay. And is the roof on it?
The roof, it is framed and it is sheathed. I don't recall that there was any tar paper or shingles at that point in time.
Was the interior at that time finished, do you know?
It was not.
Okay, after the email that we marked as T2, did Mr. Brasso continue to build the structure? Do you know?
Construction, I believe, continued.
I want to ask you about the building permit, Mr. Kachansky, that was issued. When was the building permit for 131, 133 applied for? Do you know?
It was, I believe it was early September 2018.
And when was the permit issued, the building permit?
Late October, I want to say the 22nd of October, if I recall correctly, 2018.
And you have copies of all the applications and the permits that were issued?
Correct.
Okay, what I'd like to have our court reporter mark is a plan that is, we'll mark that as T4, one sheet. Nancy, if you could identify what's been marked as T4.
T4 is a sheet A5 from the building permit bundle that was submitted as part of the application for the construction of 131, 133 Garrett Avenue. And it shows building elevations. The top elevation is the left side elevation, the bottom left elevation is the rear elevation, and the bottom right elevation is the front elevation of the dwelling units that are under construction.
Okay, so this is one of the sheets of the building permit application that was submitted. And on the right side of this, we can see the front elevation of the building. Is that right?
That is correct.
Okay. What's the date on this?
This is dated there's a revision date, number 1, August 21st, 2018, revision note, first floor framing revision.
Okay. And is the building height measured on this sheet?
Yes, it is.
Could you point out where the building height, and this was prepared and submitted by Luce Architects, who's the architect for DJB Properties, Mr. Brasso, is that right?
Correct. He's the architect of record for the approved building bundle.
Okay. And if you can describe on the plan, how is the building height measured?
Dimensionally, it is measured on the front elevation, which is the elevation on the bottom right corner of the plan. On the left side of that elevation, they show a building height dimension, 29 feet, 5.5 inches, and it's measured and it's dimensioned to the what appears to be the midpoint of the sloped roof.
Okay. And is that an accurate or a code compliant height measurement on this plan?
Not on this plan, not in the Garrett Hill district.
Okay. And where should the height be measured to on this plan?
In accordance with the zoning regulations in Garrett Hill, it's to the peak of a sloped roof.
Okay. And does the township measure building height in other zoning districts differently?
We do.
And what is it in other zoning districts?
It varies, but typically on a sloped roof, it is to the midpoint of a sloped roof.
Okay. But not in the Garrett Hill district?
Not in the Garrett Hill. It's specifically called out to the peak of a sloped roof.
So the plan that we're looking at was submitted with a 29.5 building height, which on its face would be 30 feet, the Garrett Hill requirement, correct?
Except that it's to the midpoint of the roof, and
Right. I'm going to ask you about that. And based on this plan that was submitted, or this sheet, which was part of the overall set of plans, the building permit got issued, correct?
correct.
And that was an error on a part of the building inspector, the plan reviewer that issued the permit, correct?
That is correct.
When this was going through the land development process, because this was a land development, and the building review process, did you get any phone calls or emails from the architects regarding the Garrett Hill zoning district regulations?
Not that I can recall.
Did anybody else on Mr. Brasso's behalf call you and ask you to clarify anything about the Garrett Hill zoning district regulations?
Not that I recall.
And you're also the zoning officer, is that right?
Correct.
So going back to what we marked as T1, just explain again what the violation is that's in front of the board here tonight, and why you issued it, and the section that you referenced in T1.
There are two sections that I'm referencing in the violation notice under specific violations. Number one, Chapter 280, Section 49.5 establishes the definition for building height as follows. Building height, the greatest vertical distance between the mean level at existing grade in front of a building or structure along the street right-of-way, measured to the top ridge of a sloped roof, and I emphasize and underlined in bold, to the top ridge of a sloped roof, or to the top of a roof parapet. Chimneys and uninhabited spires shall not be included when measuring height. However, elevator penthouses and stair towers shall be included. Roof-mounted HVAC equipment shall be placed in the center interior area of the roof and shall be screened from visibility from public cartway. Second section that I referenced, Chapter 280, Section 49.6A, parentheses 2A1, limits a building height to a maximum of 30 feet. Then I further note, as you are aware from previous communications and meetings with township officials, the dwelling units currently under construction exceed the height limitations. As defined in the above noted code sections, you are advised to cease all construction activities until this matter is resolved.
Okay. And these sections that you've cited, 280, that's the zoning chapter, is that correct?
That is the specific section of the zoning ordinance that has regulations for the zoning district in which this property is located in.
Okay. Mr. Kachansky, there's been some documents filed with the zoning hearing board, and Mr. Brasso came to a public meeting and criticized the township's website in terms of finding the zoning ordinance on the website. Are you familiar with the township's website and where you can find the zoning code?
Yes, I am.
Could you come down here for me and put this up on the screen and tell me how you find the building height in Garrett Hill zoning district? Show the board.
Sure. One would come to the township website. I'll just refresh the page to the township homepage. Quarter way down, there's a button it's towards the middle of the page called Municipal Code. You would click that link, which opens up a link to our e-code that is online. This has the charter as well as all of the various chapters of the code of Radnor Township. At the very bottom of the page, you go down to Chapter 280, which is the zoning ordinance. You can click on that link, and that will open up the chapter for zoning. From there, you would go to the individual property zoning district at which the property is located in. In this case, it would be the Garrett Hill zoning district. You can click on that. That opens up the section article for Garrett Hill. You can further then click on definitions or the specific Garrett Avenue neighborhood, the GHN, which this property is located in.
Let me just ask you a question. There's a GHN, there's a GHGA, there's a GHCR, there's a GH, are they different sections of the overall Garrett Hill zoning district?
There are different zoning districts within the Garrett Hill overall area. The Garrett Hill zoning district has separate individual sub-districts along Garrett Avenue, along Conestoga Road, and these are regulations for those sub-areas.
Which one of those sub-areas is this property in?
The Garrett Avenue neighborhood.
So if I'm looking for building height, then in the GHN district, where do I find that?
You would click on the, that section 49.6, and you can scroll down to subsection 2A, building size, building height and roof lines, subsection 1, not to exceed 30 feet. And if,
That's clearly 30 feet in the GHN, is that right?
correct.
So how do I then define building height in this particular district?
There are separate definitions in the Garrett Hill zoning district section of the zoning ordinance. You would go to the definition section and scroll to building height, and that is the definition, which is what I noted verbatim in the enforcement notice.
And that requires you to measure to the ridge line, top of a sloped roof, correct?
Correct. It says measured to the top ridge of a sloped roof. I'm highlighting that here for ease of read.
Not the way it was measured and submitted by the owner's architect.
That is correct.
Did anybody ever, from Mr. Brasso, ask you about this or inquire as to this particular zoning district and any special regulations?
Not that I'm aware of.
And this was approved in the GHN zoning district?
Correct.
And this was approved in the GHN zoning district, is that right?
This was approved in accordance with the regulations for the GHN district.
Mr. Kachansky, you can sit down. I have no other questions for Mr. Kachansky.
Counsel. I'm sorry, technically, could you enter your appearance
Oh,
so
yeah.
we can get going?
Mark Danek, M-A-R-K-D-A-N-E-K. I'm attorney for DJB Properties. Thank you. Mr. Kuchansky, when applications are made for building permits, do you review any of the drawings as they come in before the building permits are issued?
I do not review every building plans that come in, no.
So you said you do not review every, so do you review some?
There are occasions when the plan reviewers who are tasked with reviewing the building plans for compliance with the codes, when they have issues, they bring to my attention, and then I will review those specific issues.
Okay, and in this instance, with respect to this project here, were there plan reviewers involved in reviewing the drawings as submitted in August of 18?
There was, the township at that time employed Keystone Municipal Services, and Rich O'Brien was the representative from that company that performed the plan review.
Okay, and what specific tasks were they charged with reviewing?
As the plan reviewer, they are tasked with primarily determining compliance with the building codes and other regulations of the township that are applicable.
Okay, are they also tasked with reviewing for zoning code?
Yes.
Okay, and in this instance, the plan reviewers did do that review?
Yes, there are certain things that are looked at on a site plan during land development and grading permit. Things such as building height, which is not, that level of detail is not shown, are reviewed during the building permit stage. And the plan reviewers are to look at those items.
Okay, and with respect to this application, did any of those plan reviewers call out a possible discrepancy between the, say, the height of the project as drawn versus the height compliance with the Garrett Hill neighborhood zoning district?
There were no issues that were brought to my attention regarding the building height during the plan review process.
Okay, and did you, aside from the plan reviewers, did you conduct any independent review of the plans as submitted?
At which point in time?
Prior to the issuance of building permits?
Not that I recall.
Okay. And I think you testified earlier that it was in late February when you, I believe a neighbor had contacted you about a possible height violation with the property?
A resident reached out to the township manager, I believe it was February 23rd. Township manager brought the issue to my attention, and I looked into it either on Sunday or that following Monday when I came into the office.
Okay, and during this time period in, I guess, late February, were there any official cease and desist orders issued?
I did not issue a cease and desist order.
Okay, so it wasn't until T1 where there was an official cease and desist order, correct? Which is dated June 6th of 19?
T1 is an enforcement notice. I wouldn't classify it as a cease and desist.
Okay, well then what then do you view as the difference between an enforcement notice versus a cease and desist order?
The enforcement notice is identifying an issue on site in violation of the code and is highlighting that to the property owner and giving them the opportunity to correct it.
And then what is a cease and desist notice?
I don't know that I did not, again, issue a cease and desist.
I mean,
Well, I guess my question is more specific, is what in your mind is the difference between an enforcement notice versus a cease and desist notice?
we'll stipulate that this was the first
Okay.
written, official cease and desist, violation notice, stop work order. This was the first one.
And then, Mr. Kochansky, are you aware of any other appeals being filed pursuant to the issuance of the building permits by any neighbors in the, say, in the township?
Can you rephrase that?
Well, I guess what I'm trying to establish is that it appears that by no later than February, I think you said 23rd or 25th, a resident had contacted you indicating they believed there was a height issue with the project, correct?
Well, I testified that they reached out to the township manager, who then brought it to my attention.
Okay, and then my question is, say, within the next 30 days by March 23rd, were there any official appeals filed by any neighbors related to the issuance of the building permits claiming there was an alleged zoning height violation?
I'm not aware of any appeals filed by any entity.
And you went through the website just now on display to click through I guess the links on the website, correct?
Correct.
Now, do you know if what you just did today, the website, do you know if it's been updated at any point in time since August of 2018?
I'm not aware of any updates to the website with reference to links between on the E-code website.
Okay. I don't have any further questions.
Okay, do any of the members of the audience who entered an appearance as a party to this proceeding have any questions for this witness? Seeing none, any members of the board have any questions for this witness?
One, are you, Kevin, do you know one way or the other after the June 6th notice, whether there was any further work on the site?
I believe work continued after that point.
So Kevin, my question is, I'm looking at this diagram, and there is a line that goes not all the way to the top of the building. I guess it's the midpoint of the roof line,
This
I
is
guess.
T4, George?
What's that?
This is T4?
Oh, I'm sorry, T4, yes.
plan, thanks.
Yes, the plan, sorry. 29 and a half feet, but anyone looking at this can clearly see that the top of the building is much higher than that line. So, you know, if somebody from Keystone went on the website, like you did, they'd be able to see that the test was the top peak. And looking at this, it's clearly evident that the top peak is well in excess of the 29 and a half feet. So I guess, why wasn't that picked up?
I can't explain why the plan reviewer did not pick that up. I can offer that as we have new code officials that come on board in the township, whether it's in-house or through third party, that we go over the zoning code in general, because there are differences throughout the code in different districts. The WBOD is different from some of the other districts. The Garrett Hill zoning district has unique parameters in there. So we go over those as they would relate to the building aspect of it, and it's expected that the code officials review that as part of their plan review.
And T4 was the basis for issuing the building permit?
It was one of the sheets included in the plan set that was the basis for issuing the permit, correct?
Okay, and Keystone signed off on it?
Correct.
Okay, thanks.
I just have a quick question. Looking at T4 as well, so the 29.5 feet there's a center, and you'll excuse me, I don't know what to refer to the pitched roof as, but on the left and right of the houses, the 29.5 feet appears to be, well, let me try and rephrase that. The left and right side of the houses would be at 29.5 feet, correct? Am I reading that plan correctly? In other words, it's only that center piece that appears to be too high.
Well, it's the Garrett Hill district is different in how they measure. They measure to the peak of the roof, so the 30 feet would need to be to the uppermost part, and now it's to the middle point of the roof.
Okay. When you're referring to the middle point of the roof, you're referring to the center.
We in essence take from the bottom eave of the roof to the top ridge, and when you measure to the middle point of the roof, whatever that dimension is, you divide that in half, and that's how far up you would measure. Garrett Hill is different. You don't get into that measurement. You just measure to the peak of the roof.
To the peak of the roof. Okay. All right. Thank you.
Okay, no further questions for,
Just one follow-up for Mr. Jansen. That building permit plan, nowhere on that peak roof is there 35.5 feet measured. There's no measurement of 36.5 feet. Is that right?
There's no measurement to the ridge of the roof
To the ridge.
shown on the plans, correct?
You've got your 29.5 at the midpoint, but the architect didn't put any number at the ridge line of that roof.
That is correct.
I guess just one follow-up, just to make sure that the record's clear. You do agree, though, that on the front elevation at T4, the ultimate height, just by eyeballing it, is certainly higher than 29.5 feet, correct?
Correct.
And that's all. Thanks.
okay, next witness.
Mike Gerard, I'd like to call Mr. Gerard, as a cross, since he's the architect for the applicant.
Okay. Yeah, I guess that's now the, yeah. Yeah, that'll be the witness stand.
Thank you. Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yes.
State your name for the record, please.
Michael Gerard, project manager of Loose Architects.
And Gerard is?
Girard.
Mr. Gerard,
Yes.
You're one of the principals in Loose Architects, is that correct?
I am a project manager with Loose Architects. I've been with them for 14 years.
For 14 years?
Correct.
And as a project manager, what is your role there?
A little bit of everything. I do the zoning and code review. I meet with clients when they're looking to do a new project. If it's a renovation, I do the measurements. So in a small firm, we wear many hats.
Okay. And I'm looking at a memo that's dated June 28th, 2019, which Mr. Brasso's counsel submitted to the zoning hearing board regarding this particular project. And let me mark this as T5. Okay, Mr. Jordan, you've seen this memo before, haven't you?
Yes.
Okay. And this was sent from Mr. Luce to David Brasso to address this height disparity issue. Is that right?
Correct.
Okay. And in here, and do you agree with the methodology that's listed in here and described in here by Mr. Luce?
Yes, I would.
Okay. So, there's a couple different headings on the front page of this. The first is pre-design phase. And what Mr. Luce is telling Mr. Brasso is that before starting a design phase, a representative firm reviews the local zoning and building codes in the area the project is located, correct? That's
Correct.
what you would do?
Yes.
Okay. And if there's any need for further clarification, then there's a phone call made to the municipality regarding any questions about the code, right?
Yes.
Did you make any phone calls? You were the project manager for this project, is that right?
Yes, I was.
Did you make any phone calls to Mr. Kachansky or anybody in the zoning and building department at Radnor regarding the building height?
I did not.
So you looked at the 30-foot height limitation and made the assumption that it went to the midpoint of the roof when you did the plans, is that right?
I did not assume. I went to where the typical definitions are at the beginning of the zoning chapter, where I found the definition for the building height defined as the average grade to the midpoint of the roof.
Okay. So you're referring to, in Chapter 280, Article 1 of the zoning code, which has the general definitions and word usage throughout the zoning ordinance. That's what you looked at, is that right?
Correct.
And that's where you read the building height definition, which is different, as you now know, from the Garrett Hill building height definition, correct?
Yes.
Did you know that this project was in the Garrett Hill zoning district?
I did. That's where I came up with the 30 feet because the other districts are 35 feet.
So you went to the Garrett Hill zoning district regulations, found the 30 feet, but never read the building height definition?
I read the building height in the beginning of the zoning. I went to the Garrett neighborhood where it showed the 30 feet. And
But you didn't read the definition section of the Garrett Hill zoning district regulations, did you?
At that point, I was unaware there was a separate definition.
Okay. So, page 2 of this memo that's been marked T5. It says at the top, this is Mr. Luce's letter, in regards to the current status of the project, our understanding of Radnor zoning code was clear and verified at different stages throughout the documentation process. So explain to me when Radnor zoning code was verified at different stages by either you or Mr. Luce.
It was verified at the schematic design stage when we do the initial zoning review.
But you didn't verify it with Radnor Township, you just looked at the zoning code and came to the wrong conclusion, correct?
We only review if there's a question, that's when we reach out to the township.
And you didn't have a question, so you never contacted anybody from Radnor, and because you didn't know there was a question.
We didn't know there was a question, and the building permit was issued. We weren't aware if there was any issues.
So his next sentence says, our interpretation of the zoning code was confirmed by the building official responsible for approving the plans and issuing the building permit last year. So what does that mean? It was confirmed. Was that a phone call? Was that an email? Was that a letter? What was that?
It's knowing there was no questions that were brought up in the plan review process by the township.
And then the next paragraph, Mr. Luce criticizes the township's website regarding the hyperlink at the top of the page for the zoning district we're in. When you looked at the zoning ordinance, is that what you looked at? You went to the website and just clicked on zoning like Mr. Kachansky did and looked at the general definitions in the front of the ordinance? Is that what you did?
I clicked on the zoning, brought that up, went to the Garrett Hill neighborhood, and it just bypasses everything and goes right to the Garrett Hill neighborhood where it defines, or where it shows the building height to be measured to 30 feet. I then went back to the beginning of the zoning, and that's where I found the definition for the average grade to the average point of the roof.
Okay. Mr. Luce says, in doing the research, at the point where you get to the zoning district, we read the information from the beginning to the end of the chapter. So, you didn't read the whole Garrett Hill zoning district regulations from the beginning to the end of the chapter, did you?
We read from the Garrett Hill neighborhood zoning district, which is where this is located.
But that's only part, that particular sub-area is only part of the Garrett Hill zoning district regulations, correct?
Correct.
You now know there's definitions. There's a provision in the zoning ordinance that says if there's a conflict between anything in this zoning district and any other part of the zoning ordinance, the Garrett Hill definitions control. You now know that, right?
I do know that now, yes.
When were you first engaged by Mr. Brasso on this project?
I think it was 2015 when it first initiated.
Okay. And when did you put together any plans in 2015?
There was multiple plans. We did, I think, hand sketches, I believe.
You did what?
Just hand drawings.
And did you attend any of the planning commission meetings?
No, I did not.
Did you attend any meetings with representatives of the Garrett Hill Coalition?
No, I did not.
None of the residents? You never spoke to any of the residents or attended any meetings with any of the residents?
No.
Mr. Luce, I'm going to ask you to identify a plan. That your firm prepared. Got it dated June 15th, 2015 on it. Six. Mr. Luce, do you recognize what's been marked as T6?
Yes, it's been a while since I've seen it, yes.
And what does this show?
It shows a conceptual floor plan and elevation.
Okay, so the left side is the front elevation of a proposed twin,
Correct.
correct? And is that the same twin that was filed for a building permit
No,
2
it's
years later?
No, it's evolved.
Okay. And how about the first floor area and the second floor area? Is that consistent with what was filed
No,
2 years
it's-
later for building permit?
No, it's a little bit different.
Okay. And there's no floor area for a loft on this particular plan, is there?
Not at this time, no.
Okay. Do you recall whether there was a loft plan for the third floor of this particular proposal?
Not at this time, there was not one.
There was no loft. Okay. So that was the The dormers were just an attic, and that was the roof line at the time. Is that right?
At the time, yes.
And
Mr.
then-
Rice, I'm sorry, relevance here? Where are we going?
This really this really goes to the good faith element in this case, which I think is important. You know, what was presented to the township, the members of the community, and then what was ultimately filed.
Okay, thank you.
So this is 2015, and then the land development plan was filed in 2016, correct?
I believe so, yes.
Okay. And what happened between this plan and then the plan that was the building permit plan that was ultimately filed with the township? What were the changes? What were your instructions from Mr. Brasso in terms of the changes?
He was looking at other options to have a nice product on the site.
Okay.
That was it.
And at what point was the habitable attic area added to the plans? Do you recall?
That, I don't know, it's 15 to 18 is a lot of time. Maybe 2017 when it came back online. I don't know off the top of my head.
Okay. But this didn't have a living area on the third floor. This was just a standard.
This was just a conceptual design of what could fit on the site at the time.
But you think the third floor attic area, habitable attic area, was added 2017, to your best recollection?
My best recollection.
Okay. Obviously, you're aware of the height problem that we have in front of the board. And when were you first informed of the height discrepancy?
That was, I believe, the end of February.
Okay. And then Mr. Brasso told you that Mr. Kachansky had informed him there was a height discrepancy, correct?
Correct.
And then what did you do after that?
I gave him an email, I believe, with how we interpreted building height with the definition from the average grade to the midpoint.
Okay. And at what point did you find out that you interpreted it wrong?
It wasn't until the end of April when we got another follow-up email from David.
Okay.
And I did further research.
Did Mr. Brasso ever ask you what it would take to reduce the height of the building?
It wasn't until I think it was after the meeting with the township on what it would take.
And what would it take to reduce the height to bring it into compliance?
The entire roof would have to be removed.
Which would mean the shingles and everything else, and then you would lose the third floor living space essentially, correct?
Yes.
Okay.
I believe so.
Have you done any plans to show how that can be done?
No.
Did Mr. Brasso have you do anything to try to bring this building into further compliance?
There was a question from the township in regards to lowering the ridge 2 feet, so I did do drawings to meet their request to lower it by 2 feet.
But it could be lowered, let's say, 5 or 6 feet also, could it not?
Not easily. Even the
Okay.
2 feet was a...
But it could be done. It could be lowered 5 to 6 feet.
Not easily.
But you would lose the third floor living area, correct?
I believe so.
And then you'd put a roof on the roof would have to go back on with the first and second floor intact without affecting the first or second floor.
But
correct?
depending how the framing is done, it would be in violation of the roof pitch. I believe it's a 612 is the minimum roof pitch for the
Okay.
garret.
So that might be a compliance problem also.
Yeah, because currently it's a 612.
In February of 2019, when you found out about the height issue, how far along was the construction on the roof at that point?
I was unaware. We were not
Would you agree it would have been easier to fix it in February of 2019 versus August of 2019?
It could have been, yes.
So you don't have any concrete estimate what it would cost to bring this into compliance at this point, do you?
No, I don't handle that aspect. I just,
No one's asked you to look at that?
we don't do estimates on construction cost.
And Mr. Brasso had came to a Board of Commissioners meeting and essentially said that the township made a mistake and my architect made a mistake, and this is where we are. Has he made any kind of a claim against your firm?
What do you mean by claim?
A claim because of the plans that were filed
No.
incorrectly?
No.
Okay. And you never attended any planning commission meetings, and you never met with any of the residents?
No.
Your sole research on the zoning compliance was going on the township's website and having an issue and to get the correct information. That's all you did. Is that right?
Correct.
Okay, no other questions for Mr. Gerard.
Mr. Denick?
Mr. Gerard, in your experience, is the Radnor Township zoning code with respect to the definitions of the height, are there any differences between the Radnor code versus other codes you've reviewed?
I'm doing research for the Borough of Conshohocken and for another project for Mr. Brasso, and the building height, it says 30 feet, and then right next to it, it defines how the building height is to be measured in that specific zoning district.
I'm sorry, then.
It's how the Borough of Conshohocken, in the particular zoning district that the other project that Mr. Brasso is having us work on, it states the building height is 35 feet, and right next to it, it says how to measure that building height.
Okay, and that qualifier in the Conshohocken code, is that something you would typically see when there's a specific, say, height regulation for a specific zoning district?
Most times it's in the very beginning of the zoning chapter, under just everything lumped in together in one definition area.
In the general definitions at the beginning, correct?
Correct.
And when the plans were submitted to the township in August of 2018 for review for the building permits, did anyone from the township ever contact you with questions?
There was a question brought up in regards to the sprinklers, if they were definitely required or not.
And what was the issue with the sprinklers?
The issue was some jurisdictions enforce for twins, they want to see sprinklers. We provided documentation to show they weren't required.
So I guess the initial conversation was that Radnor wanted you to put sprinklers in, and then you showed to them their own code that it did not require sprinklers?
It wasn't in their, it was the Pennsylvania code that showed that sprinklers are not required. I don't remember exactly how it was brought up. I just know it was one of the questions that came up in the review process.
Okay, and other than the sprinkler issue, did any of the, say, planners that were doing the review, were there any questions pointed to you with respect to the height of the structures?
No.
Did Mr. Brasso, did he ever instruct you to violate the zoning code?
Never.
Did he ever ask you to build something higher than what was permitted, ever?
Never.
You touched on briefly what would be involved in lowering the roof, correct?
Yes.
And you had mentioned taking off the roof.
Correct.
And what happens when you take off the roof?
It's going to be damaged. The interior is going to be damaged by the weather. It's compromising the structure.
Okay, and when you say compromising the structure, what in your opinion would happen?
You'd have to brace it to make sure that nothing below would shift. You run the risk of cracks in any drywall, anything that's installed, let alone the moisture issue.
And how would you, if the entire roof is taken off, how would you seal up the building to ensure that water didn't penetrate if you were trying to lower it?
I'm not really sure. I'm not a logistics person, unfortunately, with that aspect.
And do you have any idea how long it would take time-wise to actually tear off the roof, reframe it, and then put the roof back on to get it in compliance with the zoning code?
The only way to judge that would be to see how long it took to put it up there and estimate a time frame to do the demo.
And with respect to T6, the plan that's on the screen right now,
Yes.
you had said that this is I believe you called it a sketch.
Conceptual design.
And in your mind, what is a conceptual design?
That is just an idea. It's not locked in stone, as far as I know.
And it's nowhere near what the final product would be, correct?
No, things evolve all the time.
Right.
Other
And then
precedents.
on T6, are there any dimensions listed for the height of the property?
No, there is not.
I don't have anything further for this witness.
Are there any questions from any of the additional parties to the proceeding? Mr. Barker.
Hi, thank you. If you look at this elevation, and you were to take this 20-foot dimension that's listed, and you were to use a scale, and you were to use a scale to measure the roof height, would it not in fact measure 30 feet?
I don't know. I don't know how the drawing was inputted into the sheet at the time.
I'm going to mark off 20 feet.
Do we know whether that drawing is to the same scale as the floor plan is? Okay, Mr. Barker, there's no indication that the floor plan is on the same scale as the draft that you're marking up there. So I'm not certain.
I understand. Thank
So
you.
then,
I understand. I think
so then
also
this is
goes-
irrelevant, and
This
it-
goes to the good faith. Thank you, though. Thank you for your consideration.
Where's the actual plan? Why are we looking at this?
Are there,
Please don't yell out. You have a chance to come up to the microphone.
ma'am, first of all, you're not, I don't believe you're a member of the group that joined as a party. Secondly, you will have the opportunity to speak. Third, we are considering the evidence that's being brought forth by the parties at this time. And this is perhaps the opportunity that I was going to take a bit later in the proceedings. Unlike many meetings that you are perhaps accustomed to attending, Board of Commissioner meetings, Planning Committee meetings, Planning Commission meetings, this is a quasi-judicial proceeding. We admit evidence, we consider evidence, it is questioned by parties. There will be an opportunity for a form of public comment, provided that the comment is relevant to the issues that are before the zoning hearing board. So, first of all, I appreciate everyone's time and interest in coming out, but the proceeding that we are undertaking here is a bit different than a lot of the meetings you're accustomed to participating in or watching on Channel 30 on FiOS. I don't know what the channel is on Comcast. So it's not appropriate to offer unsolicited questions from the audience. Questions are going to be recognized by the chair. Parties will be given the opportunity to put their cases on and to cross-examine the evidence that's brought forward. But, and I appreciate your patience, but this is a different sort of a proceeding than a lot of what you're perhaps accustomed to seeing. Thank you. Are there any other questions from any of the additional parties to the proceeding? Okay, questions from the board.
A couple questions. Mr. Gerard, about how long as a career have you been reviewing plans for zoning compliance?
It's been 14 years.
Does your career go back to a point prior to when plans, or prior to when codes were readily available online?
Yes, I've been doing it since '99, so it's been 20 years I've been working for an
So,
architect.
so back at that point, how would you review a code in order to confirm compliance?
Some townships we had is the actual code books we purchased from the township. Other times we would have to call and ask them.
And currently, an option is to print out the code offline and to review a hard copy in front of you.
I believe that is, yes, on the
Okay.
E-codes, I think it lets you.
In this case, is that something that you did?
I printed out the Garrett, the neighborhood, the district that it's in, and the, unfortunately, the zoning definitions in the beginning of the chapter.
So you printed the section of the Garrett Hill zoning district?
Just the section of the Garrett neighborhood that the house is constructed
Okay,
in.
I understand. Were you the individual exclusively responsible for this project at Luce, or did you work in conjunction with anyone else?
Well, I do the code review, and then we have the designers, once we get the design program of how many bedrooms, what the scope of the project.
But in this
is.
universe of code issues that we're dealing with, it was you.
The code is primarily me, yes.
How regularly did you deal with Mr. Brasso in terms of going back and forth? Did he, for example, review all the submissions that you made to the township before they were submitted?
We didn't handle any of these submissions. These drawings were given to Mr. Brasso, and he's the one who met with the township during the different presentations.
When we had this discussion about confirming the compliance with the height and the confusion regarding what definition was appropriate, what was it that you were reviewing there to make your determination regarding the height?
I'm not really sure. I'm not really sure I understand 100%.
Okay. Mr. Rice showed you the exhibit. Well, perhaps I misunderstand. We have the email from Luce that we talked, that you discussed in your testimony regarding how the measurement.
I measured it from the average grade to the midpoint of the roof, just like the plan reviewer interpreted the same.
And you did that measurement off of plans provided by whom?
We documented the plans.
Okay, you documented the plans and then you did the calculation. To what extent and at what point did you interact with Mr. Brasso in terms of that process?
We did it all internally, and he he took our plans and submitted it for permits.
Okay, so he had zero input into the design of the building before he dropped the stuff off at the township?
Well, the only, his thing was, let's see if, can we maybe take this bedroom and maneuver it this way? Can we get a little bit wider hallways or a little bit extra closet space is always a design thing that he likes to see, is bigger closets. I mean, that's,
Okay, so there was some level back and forth. Understand your testimony regarding height. You're saying there was no discussion regarding the height of the building. The discussion had to do with these nuances of interior design?
correct.
Okay. My last question. You indicated that at some point in the process, you were asked to do a design 2 feet lower.
Correct.
And you were pretty precise. You said the township asked us to do 2 feet lower.
Yes.
I just want to make sure that it wasn't, was it that precise? The township said lower 2 feet, or the township
They
said,
said lower it-
can it be lowered a little bit?
They
You
said
came up with 2
lower
feet?
it, minimum of 24 inches, is which the proposed design that we had done met that criteria.
Okay. All right. Thank you.
Yes, I'm going back to my favorite exhibit here, T4, which is what's up on the screen. And I understand now why the height is listed at 29.5, because the understanding was that the test was the midpoint of the sloped roof. That was understanding, right or wrong.
That was our interpretation.
Got it. Okay, so you knew that the building actually was 36.9 feet, correct?
No, I knew it was 30 feet because that's the way I interpreted the building
No,
height.
I'm sorry.
I didn't have anything
Forget
to hide.
about the
We showed
zoning
it.
rules. The actual height of the building. You and your client, I assume, knew it was 36.
I never measured actually from the midpoint up. I mean, I always interpreted just to the average thing. I never really measured from the lowest to the highest point until after.
Understood. So, and this is, hindsight, but I think it would have been very helpful on a schematic drawing like this to have the actual real height of the building to the very top. And then you would have seen a number on this sketch of 36.9, which, might have been helpful in this analysis. But if in your interpretation of the rules, a certain measurement like that isn't relevant, you don't include it on the drawing, or?
No, if it's, we interpret it was to the midpoint, so that's how we showed it, to show that this is how we're meeting our compliance of the 30 feet. That's how we interpret it, and that's how it was submitted on the permit drawings. We showed everything how we interpret it. If there was any issue, it should have been brought up in the permit review process.
All right, thanks.
No further questions. Mr. Rice?
Mr. Gerard, you were asked by Mr. Danick about what would happen if the roof was taken off, and I think you said there would be, rain could get in, there could be damage, that kind of thing.
Correct.
I mean, that was just generally your testimony?
Yes.
Okay. But you would protect the rest of the building. If you had to take the roof off or lower it more than 2 feet, whatever it is, and you'd have to cut the joist somehow, but you would still put some kind of protective covering on it to protect it from any rain infiltration.
There's still no guarantee that moisture's not going to get in. And
Well, if I
cause
put a
issue.
new roof on my house, what do? They take all the shingles off, and it's exposed, and there's a storm coming. What's the roofer do to protect the house?
Hopefully you don't hire my roofer because he left it wide open in my shed, so it
Well,
was
what
damaged.
what should he have done?
It depends how big of the roof is being done. Usually they get that done in a day.
But it can be tarped, right? Roofs get tarped all the time to protect it from weather, don't they?
That's not my expertise, I'm assuming.
Well, you had your house done.
I had my shed done.
If he had tarped, if he had tarped the shed, it would have been protected, right?
Well, that's a lot smaller than a house.
So, Mr. Brasso has submitted some other information to the zoning hearing board regarding money that's been expended that would be lost if he had to reduce the roof. And I want to ask you about some of that. Site work, excavations, and foundation work that's been done. If the roof was changed, that wouldn't touch the foundation or the excavation or the site work, right? I mean, that wouldn't be disturbed.
It shouldn't.
Okay. And what about framing below the roof, the rest of the house?
The framing, I know in the design we had proposed, we had to feed 2 big beams into the attic space, and they would have to be posted all the way down to the foundation, so you'd be ripping into the walls on the second and first floors to feed additional structure in to support the lowered roof pitch.
Okay. Mechanicals and, other than what has been installed in the attic, habitable attic area, the rest of the mechanicals in the house wouldn't be impacted by replacing the roof, would it?
Again, if we'd lowered the way we had it designed, it may. I'm not sure where the mechanical ductwork was run, where those beams would have to be pocketed down the post.
Right. But things like flooring and appliances and finishes on the first and second floor, assuming you protect the roof, they wouldn't be impacted by fixing the roof, would it?
Assuming it's protected sufficiently enough.
So, Mr. Brasso also gave a few other calculations to the zoning hearing board in his brief, and he says materials and labor to lower roof, $50,000. Did you have any input into that?
No, we don't give estimates for cost of materials. We're not. It changes constantly. Wood is a commodity. It changes prices.
And one other thing, I had subpoenaed you to be here and to bring some records with you.
Correct.
And I want to just show you one memo from your file, which I guess would be T. I only have the one copy. You can mark that as T7. Mr. Gerard, these are handwritten notes from your file regarding your conversations with Mr. Brasso, correct?
Correct.
And what's the date on that memo?
March 14th, 2019.
March 15th?
14th.
14th. And the sections that I highlighted, could you just read those into the record?
He said since he had a permit, he was building, and they had not given any official stop work order.
And go ahead.
Too far along to stop. He has the permit and no official stop work notice.
So even though you knew and he knew that there was a zoning violation, he was going to continue to build, correct?
We did not know there was a zoning violation at the time because we were still interpreting the building height from the average grade to the midpoint.
But didn't Mr. Brasso, when you had that conversation, know that there was a height problem?
We knew there was a question. We don't know. On our end, we didn't feel it was a problem at that point. Weren't aware of the additional definition.
Well, you've been sitting here. You heard Mr. Kachansky testify that he informed Mr. Brasso in mid-February or late February that there was a height problem.
That there was a question in the height.
So at that point, it was your impression that the zoning violation hadn't been confirmed yet? Is that your testimony?
I had not heard any otherwise, that it wasn't confirmed one way or the other at that point.
But from that conversation, you would agree that because there had been no official stop work, even though there was a question regarding the height, he was going to continue to build, right?
Yes.
I have nothing else for Gerard.
Anything else for this witness, Mr. Danick?
One last question. We had, in your, I guess, cross, you had focused on being able to reconstruct the roof to be compliant. What is the span of the roof right now?
Front to back?
Correct.
I'd have to look at the drawings. I believe it's 50 feet, 60 feet.
62 feet. Objection? Yeah. Sir, you're not testifying. If you need to check the plan, check the plan.
Well, height.
Mike, do you
There's
want me
no-
to put your drawings up? that you
Yes,
brought?
if you have them. I don't remember if I have the floor plans on there or not.
Which drawing do you need?
Yes, can I see? I don't remember if I brought a floor plan or not. Yeah, unfortunately, I don't have any floor plans. I just have everything that pertains to the building height. Is there any site plans? Because that's what the buildings were based on from...
But just to follow up with us and close the loop on this, would it be possible to make the revision that the township's requesting and still be compliant with the pitch roof requirement in the Garrett Hill neighborhood district, zoning district?
It would be under the required 612 as the minimum.
So it would not be compliant, correct?
It would not be compliant.
Okay. Nothing further.
Thank you. Mr. Girard, thank you. Anything else, Mr. Rice? So at this point, the question arises, perhaps, was the enforcement notice validly issued? Simply the issuance of the enforcement notice. Is there anything you want to say on that issue based on what we've heard here so far?
Well, can I just ask a question?
Sure.
I have another witness.
Oh, I'm sorry.
I was done with this witness, but I have another one.
I'm sorry.
Maybe two more.
Okay.
And I did subpoena Mr. Fisher from Diamond Construction. I don't know whether he's here. Is that Mr. Fisher? Mr. Fisher, did you bring any records with you? Okay. This will be a brief witness, but I would like to call Mr. Fisher from Diamond Construction.
Okay. Thanks. My apologies, Solicitor. I didn't know you had more witnesses.
He may have witnesses too. I don't know.
Sir, you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Thank you. And state your full name and spell it, please.
Gary Fisher, Gary Fisher.
Good evening, Mr. Fisher. Thanks for coming. You're the contractor on this project we've been talking about, 131, 133 Garrett Avenue?
That's correct.
Okay. And have you worked with Mr. Brasso before on similar projects?
Yes, I have.
And how many other projects have you worked with him?
Probably 15, 20.
Okay. Residential projects?
Yes, all residential.
Single homes, twins?
Singles, townhouses, different things like that.
And with respect to this, you're familiar with the height dispute regarding this particular project? You're familiar with that generally?
It's been brought to my attention, yes. I didn't know anything about the ordinance.
Right. You wouldn't have been responsible for that.
Correct.
You got the building permit plans and then you built.
That's correct.
Okay. Do you remember when it came to your attention that there was a discrepancy of about 6.5 feet between the ordinance limitation and the actual built?
It's 35.4, but if you want to be exact about it, it's 35.4. So it's a difference of 5'4". That's the exact measurement.
Okay.
So it was brought to my attention. I can't really give you a date, so I don't really remember. But when David came to me, the windows were in and the roof was on. I do remember that.
But the roof wasn't finished, right?
The roof had shingles on it, yes.
Had
it did.
shingles on it?
Yes.
When he brought it to your attention?
Yes, it did.
And what did he say about trying to lower the roof at that point?
Didn't say anything about lowering the roof because we, at that point, didn't know if we were right or wrong. We figured we had an approved print from Radnor Township, and everything on there was approved.
And you know for a fact it's 35 feet, 4 inches?
We've measured it.
Okay. Recently?
I measured it probably, I guess, 2 months after the date you were, we measured it later because the township asked us to measure it.
Okay. But you don't have any specific recollection of when Mr. Brasso came to you with the issue?
No, I don't have the dates like the other guys do.
So if you had to reduce the height of that 5 feet, how would you go about doing it?
Can't do it.
You can't?
You can't without taking the whole building down. It just wouldn't work. The roof's too flat. There's too many things that would have to support it. In my opinion, you can't do it without taking the building all the way down to the foundation and starting over.
I don't have any other questions for this witness.
Mr. Danick?
Mr. Fisher, how long have you worked with Mr. Brasso?
Oh, probably 15, 20 years.
Okay, and during that, strike that. With respect to this project, did Mr. Brasso ever instruct you to violate any sort of zoning code by
No.
constructing?
No.
Let me finish.
Yeah,
by constructing a building that's too big for the zoning district?
No.
And you briefly stated about that you just can't do it, I believe was your response to the question as far as lowering the roof by 2 feet?
No, that was the 5 feet, to lower it 5 feet.
To lower it to 5 feet. If you lowered 2 feet, is that possible?
It is, but it's not easy.
Okay, and when you say it's not easy, why is it not easy?
There's just, there's more to it than just building it from original. You know, when they want the way it was designed, and the way it was presented to me, how they were going to do it, a lot was involved. They were starting to get cranes involved to get those beams in. The lulls that we use to usually build the building, we can't use anymore because the building's already there. So now we have to start getting into cranes and different things like that.
Okay. And if the roof was lowered by the 2 feet, is it possible to meet the pitch requirements for the Garrett Hill zoning district, which I believe is 6 to 12?
Well, on that design, we were not changing the main roof. We were just changing the top of it. Like it was about a 5 to 6 feet wide section. So I don't know how they would interpret that. The part that we were changing would not meet the 612, but the main structure of the roof would meet the 612.
But there's still a part of the roof that would be non-compliant, correct? And you said you measured it at 35 feet 4 inches, correct?
Correct.
And when was that measured?
Probably about 2 or 3 months ago.
I don't have anything further for this witness.
Mr. Fisher, the 35 feet 4 inches you measured to the peak of the roof?
Yes.
Okay. And you couldn't reduce it 5 feet, but you could reduce it 2 feet, but it would be difficult.
Well, I was presented a plan that was also presented to Radnor, and you could do it, but it wasn't easy. The 5 feet, in my opinion, I feel you can't do it without taking it all the way down to the foundation because there would just be so many different points to meet that you'd rip the whole building apart anyway.
And you're not an architect,
No.
right? You're not a code guy. You
Nope.
said you don't read the code,
Nope.
so anything you're talking about codes, you're just speculating.
I wasn't talking about codes. I'm talking about construction.
You were asked a code question by Mr.
By
Dan.
him, but not by you.
Let me just ask you a question about this photograph.
Mm-hmm.
So this was taken in the building, this is T3.
Right.
Was taken in February 2019.
Right.
Would it have been easier to take that roof down back in February than today?
Well, today, yes.
Because your opinion is based on taking it down today, right? 5 feet?
Well,
Or 2 feet?
well, my opinion's also when we were going to do it, take it down to 2 feet too.
Right.
I mean,
So, and how many projects have you done with Mr. Brasso?
like I said, 15, something like that.
And how, over what period of time?
15 to 20 years.
So you and he have a very close working relationship?
Yes, we do.
Nothing else?
Are there any questions from any of the additional parties to the proceeding? Just your name, yes. So Norma has it. Thank you.
My name is Lauren Wiegand. I just have one question. I'm not a building person. I'm a nurse.
Okay.
So I don't know anything about buildings or anything. So I just want to know, why did you measure the building 2 months ago?
The township asked us to. Well, I mean, that was my understanding. Dave came to me and said the township would like us to measure the building, so we did it.
So you don't normally measure a building in the middle of construction?
We just go by the plans. We don't normally have to do that. So I have an approved set of plans, as long as we're following the plans. And I think that building is the plans that I was given back from the township for my permit. And I think
Okay.
that meets what is on the plan.
Thank you.
Okay.
Thanks.
Any other questions from the additional parties? Seeing none. Questions from the board?
Mr. Fisher, your testimony regarding the inability to lower the roof 5 feet, that's based on your experience as a builder.
Correct.
Did you ever have that question posed to you by your client, where you went off and essentially considered it, talked to engineers? I mean, I understand your reaction, your response is a informed response, but were you ever asked to investigate the question?
I knew about the height problem, and then a couple weeks went by, a month went by, and then we really just got into bringing it down that 2 feet. It never really got to the point where we talked about taking the whole thing off. So we never really talked about going all the way down, but we did talk about going down the 2 feet. We tried to figure it out and basically how much it would cost and how long it would take.
Thank you.
Okay, no further questions. Thank you.
Thanks.
Mr. Rice?
Mr. Brasso.
About to get sworn in? What does that consist of?
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
And state your full name, please.
David Brasso, B-R-O-S-S-O. Good. Oh, you're right. Thank you.
Mr. Brasso, describe your background.
Mr. Rice, the mic, sorry.
Mr. Brasso, just describe your business and your background as a builder.
Sure. I actually printed something out in preparation for this, if you want me to submit it. It has,
No.
Okay. I grew up in Willow Grove. I went to high school. I then went to University of Delaware, graduated with a BSBA in 1991. I went to work as a sales rep. I eventually went to Carnegie Mellon University. I got an MBA in 2009. I did a little work in finance before I went into business in a healthcare data business. We ran that for 12 years. Then we sold that. We started another small company in Conshohocken, ran that for 5 years, and we sold that. Then, and only then, did I enter into the developer business. I'm not in the construction business. That's what Gary does. I'm in the development business. So that means I find land in this case. I try to acquire it and purchase it, figure out a way to finance the land. I go and hire an architect. I hire a builder. I hire a site engineer, in this case Joe Estock, who's not here. And they help me get through the development process. It's quite a lengthy process. At Radnor, it's one of the more stringent ones. You have to go through a land development phase to see if what you're proposing to build will even meet the requirements. And then you have to go through another architectural phase. So, Mr. Rice, I've only been doing this 5 years.
As a developer?
Yes, as a developer. I'm fairly new at this. I'm, still learning and perhaps slightly naive in some respects. But I do have an excellent team behind me that has tons of experience that I trust, and it works out in most cases very well.
And your contractor over here, Mr. Fisher, he said he's been working with you for 15 years building homes, but you're only 5?
Yeah, well, I think Gary might have overestimated that. I think our first project we did about 12 years ago.
Okay.
And I did that as a side business. I was currently a sales rep at Health Market Science, and my next door neighbor passed away, and I bought the property from his children. And Gary and I thought that it would make a good site to develop. We agreed to go into partnership together and build a twin on that site. I actually have a picture of it if you'd care to see it. It was 225 and 227 West 5th Avenue in Conshohocken. It's a structure that looks not dissimilar to this one that we're talking about tonight. Anyway, Gary and I went in there and built that maybe 12 or 13 years ago. I wasn't considered a developer then. In fact, my tax records have me listed as a sales rep, not as a real estate professional. So Gary and I did that, and then a couple years later, we did another project in Conshohocken where we did a set of 4 units, so it looks like that, times 2. And again, that was a side business. I was still a healthcare data professional, and Gary and I did that as a side business. So it wasn't until a whole lengthy process where I shed that vocation and decided to make a play at being a developer. That's why there's a difference in the timelines.
Okay. So in this particular process, you acquired the land. You filed a land development plan with Radnor Township, correct?
Mm-hmm.
And Estock Engineering was your engineer.
Yes.
You had different legal counsel involved in that, as I recall.
Yeah, Mr. Pietro retired.
Okay.
Since then.
And you were aware throughout this whole process, when you bought the land and you filed the plan, that it was in this Garrett Hill zoning district, correct?
Sure, yeah.
Okay. And
Mr. Kachansky and I met on that early on, and he said that this is a different, it would behoove you to talk to the people in Garrett Hill to get their opinion on any matters going forward. And we, in fact, had several meetings with them, which is where, I don't know what this T6 came about. This was presented to the Garrett Hill folks at a meeting at their Methodist church that they normally attend on a monthly basis. They invited me to attend and present this.
Okay. So you attended that meeting with the Garrett Hill residents, and that was the plan, T6, that shows the first and second floor and a different looking structure than was actually built. That's what was presented that night.
When you say different looking, I think it's ostensibly the same type of building. There are cosmetic differences, but it's not appreciably different. If you look at T6, if you had it up there.
Yeah, let's look at T6.
Because this gets to the bad faith element, which I have an issue with.
You helping me with that, Mr.
Most certainly no.
Grasso?
I know where you're going, but I don't agree with it.
Well, let me ask the questions.
Okay.
Okay? Because T6 this is the plan that you took, you personally, right?
Sketch plan.
Went to the meeting.
Let's be clear, sketch plan.
And sketch plan, concept plan, it wasn't a formal land development plan.
Correct.
You hadn't filed it yet, correct? Okay.
Couldn't file. It's not ready for filing.
So you took this to the Garrett Hill group. Did they like it?
They indicated they liked it very much because the main point was the garages were eliminated from the front, which was their primary initial objection.
Right.
We moved all the parking to the rear. But I got to tell you, when we had the garages in the front, the building was the same. See that A-frame in the middle? That was 2 one-car garages. So all that Mike's company did was to fill that in and make it a dining room. So it's really very similar plan to the one they hated prior with the garages in front. But it didn't change much.
And this
one they liked.
This concept, they liked this, and they went to a planning commission meeting and said that we liked this plan also, didn't they?
Yeah, they did.
They did.
They did. But if you look at it, there's a ground level that's 10 feet high. There's a second floor that's 9 or 10 feet high. And then there's a roof that's 9 feet high.
I don't see any of those dimensions on here.
You
Where
don't
are they
need
at?
them. You don't need them. If you live in a building.
But wait a minute,
you
where are
can't-
the dimensions you're talking about?
Okay, see the front door?
I don't see them on
No,
the
no,
plan,
do you
though.
see the front door?
I see the
Okay,
front door.
So someone has to walk through the front door. So that first floor has to be a nominal height to even be habitable.
Okay, but where
Okay,
are
so the first floor,
Mr. Bressa, where are the dimensions you're
the dimensions
testifying
are
to?
implied.
The what?
The dimensions are inherent in this design.
Inherent,
For someone to live in it, the first floor must be 9 or 10 feet high. The second floor must be 9 or 10 feet high. Now we're at 20 feet. So this roof, in order to hold up itself, has to be more than 0 feet high. So this drawing here is in fact higher than 30 feet.
But it doesn't
Has
say-
to be.
But it doesn't say that, and your architect who did the drawing said he didn't know.
It's a concept plan.
But you know it's over 30 feet, right? That's what you're saying?
I never considered the overall height of this concept plan with respect to the zoning code that I'm unaware of at the time.
So you
Okay?
didn't know.
So your whole argument is based that I knew the zoning code back in February or
Mr.
2015,
Chairman, could you direct
2016.
Mr. Brasso to answer my question.
Okay.
And stop
Thought I was.
pontificating and arguing with me about. Agree.
Wait a minute. That's my
I'm
testimony.
asking simple questions, though, Mr. Nagel.
Let's ratchet it down a little. Please answer
Understood.
Mr. Rice's question.
So let me ask you, do you believe that this concept plan is over 30 feet high?
This concept plan has to be over 30 feet high.
Okay, so you believe that?
No, I know it.
You know it?
It has to be.
Did you tell the Garrett Hill residents when you presented this to
We
them?
never discussed building height at any
It was
point in
over.
time.
Can I finish asking the question? That it's over, did you ever inform them that this building was going to be over 30 feet high?
We never discussed building height, so no.
Okay. And this has a 20-foot width for each of these and a 52-foot length.
At
That's
this
the-
time, that's what the concept plan had, yes.
Right. And is that what was built?
No.
What was built?
We went back to the zoning board and said that this lot can handle a building at 21 and a half feet, and I had to pay money for another zoning review, and we came in here and presented to the zoning board at that point in time, and they granted us approval for a 21 and a half foot wide building.
And just to correct the record, you probably went to the planning commission. You did not go to the zoning hearing board.
Correct. Sorry about that.
Okay. So that was part of the land development process that you went through? In front of the planning commission and then the board of commissioners, correct?
Yes, you're right.
There's no third floor attic, habitable attic on this particular concept plan, is there?
I don't know what Mike had in mind at this time. We always get everything we've built since the history of me building with Gary and Mike, has a habitable attic. So I always intended if it were permitted and viable that we would have an attic. Whether it's shown on here or not, we always try to get an attic because we try to be efficient use of the space. And if we can stay within the code, we always try to get an attic in there.
Not on the concept plan, though. Doesn't reflect that, correct?
I mean, maybe
It's
Mike
easy.
hadn't.
It's
may-
either
Hold
yes
on, no,
or no.
no, because Mike
What?
doesn't always give me all the floors on one page, so there
Okay.
could be a third page to this that he didn't draw yet, so
Fair
I
enough.
don't know what he had in mind. This isn't finished.
Okay, so you presented this to the Garrett Hill Coalition. They then came to Planning Commission meeting
Hmm?
on March 7th, 2016.
I suppose, I don't.
Do you remember
Yeah.
when this was, you met with the Garrett Hill folks?
I don't know the dates, but I'm gonna trust that you have them right.
So you met with them in January 2016,
Mm-hmm,
presented this plan,
mm-hmm.
and they,
Sorry, yes.
and they seemed to like it when you were there. Is that right?
They gave me that indication they liked it, yes.
Then they came to a planning commission, or you came to a planning commission in March of 2016. And I'd like to mark the meeting minutes from the March 7th, 2016 Planning Commission meeting as T8. Mr. Brasso, on the second page of the meeting minutes, your project is listed as 2015-S-03. Do you see that?
Yes, I do.
Okay. And your engineer was there that night, and I believe you said you recall being at the Planning Commission meeting also?
Yes.
Okay. And in here, there's some public comment. And the second public comment is from Patty Barker, and that says, Patty Barker, Chair of the Garrett Hill Coalition, advised the board that the applicant has met with the neighbors. They've been through numerous discussions with him, and the coalition supports the applicant's proposal that fits the character of the neighborhood. Waivers are minor, and they were supporting the development at that time. You had some saldo waivers, minor ones that you were requesting, correct?
Yes.
Okay. And their endorsement was based on this particular plan, wasn't it?
Their endorsement was based on the concept that we move parking into the rear and build a compliant house. That's what their endorsement was for.
But other than this plan that was given to them in January 2016, you didn't give them any other plan before this planning commission meeting, did you?
We gave them, well, this is not a valid plan, this is a concept plan. The ultimate plan is 90% identical to this plan, okay? So the facade of this and the facade of what we built, they're very, very similar.
But my question was, between January and March, did you show them any other concept plan, whether it was valid or not? Did you show them any other concept plan? Or was this it? You didn't, did you?
Let the witness answer, please.
We didn't have any other plans to show them until we submitted for permits, okay?
Hey, Mr. Brasso, before you filed for the building permit in 2018, did you show them that plan or any plan?
I
of what you
wasn't
were gonna
aware
build?
that part of Radnor's process is that I have to file zoning permits with Patty Barker and the Garrett Hill Coalition. I think I have to file them with the people in this building. So I did not file them with them. I followed the procedure.
I didn't say file. I said, did you show it to them? Did you show them what you were going to do?
Mr. Rice did not, because this building, in my opinion, is ostensibly the same as the one that's built.
I understood. I just want to know
So I
whether
did
you
not.
did.
I did not. I didn't know I was aware of it. I didn't withhold it from him. If Patty had called me and said, hey, Dave, what are you up to these days? I'd like to invite you to come back in. We would have come back in and showed it to him. I didn't withhold it from him intentionally. It never occurred to me that I would need to show it to him. It never occurred to me that they would care to see it. And more importantly, it didn't occur to me that this plan that we ultimately got approved is vastly different from this plan. I mean, if I changed the shingle color, would I have to then go show that to them? I don't know where it ends. They were really worried about the parking. And once we solved that piece of the puzzle and had their support, I thought we were in good shape so long as we continued with the character of the house, which is a craftsman-style house. We carried that all the way through to the ultimate plans that were granted permits. So
Okay,
I thought
so-
we still had Patty's support and the support of all the folks here. I understand why they're upset, because the building was built too high, but we didn't intend to violate any code at any point in this process.
But you were aware, you were aware of the Garrett Hill zoning regulations?
No, I wasn't. I
You
don't
weren't.
delve through the morass of the code that admittedly is very confusing. You have a professional over there who couldn't interpret it. You have another gentleman from Keystone Properties that couldn't interpret it. And you have Mr. Kachansky that didn't pick it up either. So how can it be so easy to pick up if everybody that's paid money to look after this, they all missed it? Were they all in cahoots trying to scam me or put one over on Radnor Township? It was a mistake, because it's not very clear on how this particular roof in this particular microcosm of a district is measured.
So you know there's a microcosm of a zoning
I
district?
do now.
You know that?
I do now.
Okay. And you didn't know that there was a Garrett Hill zoning district when you went through the land development process?
We did, and we thought we were compliant. And as evidenced by our permit, we were given evidence that, from our perspective, that we were compliant. If we submit something that's not compliant, it usually gets kicked back, and we're told to make changes to the drawings and resubmit it. If I had anything wrong on the plans that wasn't compliant, it normally gets kicked back.
Understood. So, once this issue came to the forefront in February of 2019, you recall Mr. Kachansky calling you and emailing you?
Indeed.
You do?
I do.
Okay.
He and I got on the phone. He said, we think there might be a problem with the building height.
So what did you do then?
We came in and we met with Kevin and with Bob Z, and we had a discussion, and I said to them, I'm not sure what we're supposed to do here. What do you want from me? And he said, well, we got to figure out if we have a problem here. We're not sure. We may bring in another company to give us a third opinion. And I asked them point blank at that meeting, I said, guys, if you bring in another consultant and they determine that the roof is higher than 30 feet as measured to the peak of the roof, then what? What do you want from me? And Bob Z said, well, let's not get there now. Let's just wait and see if we have an issue, and then we'll get back to you.
So you met with the township staff?
I met with the township
And there was
staff.
an effort to try to resolve
There
this
really wasn't. It was a
discrepancy.
waste of a meeting.
There were some meetings to try to resolve this. It didn't get resolved, hence the zoning violation notice, correct?
The only thing that I learned in that meeting is that they thought that possibly there might have been a concern with the building, and they needed to bring in another consultant to figure out if indeed there even was an issue that was legitimate. So they were putting me on notice that there might be could be sort of some problem.
So, Mr. Brasso, when you found out in February of 2019 about the building height, why didn't you stop building at that point?
Because first of all, if there was a legitimate problem in the MPC code, they would have showed up and told Gary to stop construction. That's how the process works. Gary was never told to stop work. So when we have a valid permit, we're tasked with hitting a timeline. My bank wants me to finish on a certain time. Gary needs to get moving to other projects. We have subs that are scheduled at certain intervals that need to hit those timelines. So it's not so easy to just stop the presses and wait and see if something could be a problem, we're not even sure. But meanwhile, we have a valid permit, so all we're acting on at that point is we got issued a permit.
Mr. Grasso, you knew
No, I didn't know.
height
No,
discrepancy?
I didn't know. I knew.
February or
No,
June
I didn't know in
after?
February. It wasn't until June that I knew.
And,
It wasn't until June that I knew.
okay,
That's when we got the official notice.
you kept building after you were notified?
We had a valid permit, and we weren't told there was an official notice. John, there is an MPC code that governs all this. If you don't follow that and you don't file something properly, then we only have what legally we have to act on, and that's a valid permit. Hearsay and conjecture and emails and maybe we got a problem and Yerkes coming in and poking around, none of that's actionable.
Thank you. I'm going to ask Court Reporter Mark, these are meeting minutes, signing from the meeting of the Brick Road Civic Association of February 28, 2009. And that will be T9. So, Mr. Brasso, this is a meeting of the Bryn Rose Civic Association of February 28, 2019. You attended this meeting, correct?
I went to a meeting to talk with the folks at the Garrett Coalition. If it indeed was this meeting, then yes, I don't know.
Okay. Look at the second page. So your signature on the bottom of the attendance list?
Yeah, again, I was there at a meeting. If that's this meeting, then I was there.
All right, so you were there.
Yeah, I really wanted to find out what their concerns were.
And you went there because Kevin had told you there was an issue?
No, I went there on my own volition and because I spoke to, I forget how I got here, either John Child or Sean Farhi, if that's how you pronounce his name. I got a hold of one of them, and I thought it would be prudent to attend this meeting and find out what the issue was.
So in the meeting minutes, under old and new business, the second paragraph says, the new construction of a twin at 131 Garrett Avenue is 8 feet too high per the township staff who will be coming out to measure it, including the width, and if it's too near the street.
First of all, John, this is the first time I'm seeing these minutes. I was invited to the tail end of this meeting. I didn't attend this part of the meeting.
Just going to ask you whether you remember the discussion or not. Do you remember the discussion? You were there.
I remember some folks being concerned that the building was too high and blaming me that it was my fault. And I was trying to explain to them that we were only following the permit that we were issued.
Right.
And this, we're
I don't
not
think
aware.
anybody disputes that you got a permit that was erroneous issued. The question is, you testified 5 minutes ago that you had no idea that there was a height problem. Yet, here you are, February 28th, you said until, is it June? June? Here you are in February talking about the height problem.
These folks are asking if there's a height problem. Again, hold on.
Please, again, folks in the gallery.
Let's review the timeline here because it's important. The testimony that we had earlier was Mark and the folks at Luce and I were trying to figure out even how they measure the roof. We weren't aware that Garrett Hill has a different roof measurement. I didn't learn that till later on when Mike told me that he interpreted it
I understand
incorrectly.
that. My only
But I didn't know
point
it in this state.
in asking you about that is, you were at the meeting, the height problem was discussed. You acknowledge that, correct?
I will admit that some citizens had a concern that the building was too high, yes.
Okay, thank you.
They might have had concerns that the building was an ugly color, too. I mean, I don't know the litany of their concerns.
I'm going to have a court reporter mark copy of your record plan as Mr. Brasso,
Can we use the camera for this one?
oh, yeah, sorry. Mr. Brasso, do you recognize this plan? It says record plan 131, 133 Garrett.
Yes, I do.
Okay.
I'm sorry. This doesn't, this is a record plan for 20-foot wide buildings. This is not, I don't believe this is the final record plan.
Okay. Well, let's go down the right-hand side of the plan.
But it's not the final record plan.
Let's go down the right-hand side of the plan. Do you see the signatures that are listed down the right-hand side of the plan? Let's start with the first signature at the top. Whose signature is that?
That's my signature.
Thank you. And then the next block is Radnor Township, and there's signatures there, correct?
It appears that, yes.
And then there's a block that says reviewed by the Delaware County Planning Commission with signatures, correct?
Correct.
And then underneath that is your engineer, Joseph Estock. He's signed off on this.
Yeah, okay.
So you'd agree this is the record plan, right?
I don't know. I mean, it is a record plan, but we were approved for a building wider than this. So I don't know what version this is.
This is your record plan that your engineer filed and is recorded. So question I have about this is...
It's a record plan. I don't know that's the final record plan.
But this shows the two sides of the twin and proposed three-bedroom dwelling, correct?
Yeah, this is a land development plan, so this talks about everything from the ground down. This doesn't show anything from the ground up.
Yeah, but on the, endorsed on the left side, it says number 131, proposed two-story, three-bedroom dwelling. You see that? I can come over and point it out to you if you want.
It's irrelevant.
I'm just asking if you see it or not.
I don't
Just answer the question, please.
I'm sorry, I don't see that exact spot, but if you give me a minute, I'll find it and probably agree to it. Okay. But it is...
Okay.
Oh,
I'm pointing to lot number 1.
thank you. Now I see it. I was looking down here.
And lot 2 also says the same thing.
Yes, that is
right?
indeed what it says.
Bedroom dwelling.
Yes.
So underneath that, where all the zoning information is,
Right?
okay, beneath where Winston Creary's lot is, in the middle of the plan, you have all the zoning information. At the top, it says proposed impervious areas. Do you see that?
I do.
Okay. And then as you go down, it says zoning district, Garrett Hill. Garrett Avenue
Yeah, I see it.
neighborhood.
I see it.
Okay. So that's the zoning
Do you want to just
district.
skip to the part where it says 30 feet? Because we can just go to that point.
Yeah, that says, well, that says the 30 feet height is on there, right?
Yeah, we can all agree to that.
Okay. But that's
That
the
we
zo-
can all agree that this two-dimensional plan that doesn't talk about anything of the building says 30 feet. It doesn't say how to measure that 30 feet, but it does say 30 feet.
And
so-
that is the zoning district that you're
Yes, it
in.
is. We all agree on that. That's never been in dispute.
So, Mr. Brasso, there's been discussion about what it would take or what it would cost to take the roof down, lower it or remove it, replace it. And you had sent an email to Bob Zinkowski estimating it would be about $7,500. Do you remember that email?
That was to lower the roof
2 feet?
2 feet.
Okay. So you estimated $7,500, that was it?
That's an estimate.
Okay. Did you consult with your architect for that, or that was just your ballpark estimate?
Mike had a plan. Gary and I had a brief discussion. I don't know how intensely we mapped it out. I mean, they needed a number pretty quickly, so we had to get back to them with a number.
Okay, well, let's identify
What's
this.
the relevance to this number?
That's for the zoning hearing board to decide.
Okay.
I'm going to ask the court reporter to mark this email dated May 3rd, 2019 as T11.
We would have lowered it if they accepted our proposal. So whether it was 7,500 or 75,000, we agreed to lower the roof by 2 feet.
So, Mr. Brasso, do you have T11 in front of you?
I do.
Okay. Do you remember sending that email to the township staff?
Yeah, sure. It's right here. I didn't like it, but I would have done it.
And going back to the plan that we just marked, the record plan, you have that in front of you. Are you familiar with the parking requirements in the Garrett Hill zoning district?
Yeah, it's on here.
Okay. And how many parking spaces are you providing on this plan?
6.
That would be
3 per side.
three.
1
each
per
side.
bedroom.
Okay. And that's based on a 3-bedroom. That's based on a 3-bedroom.
I don't think we have an
unit.
issue with parking requirements here. It's about building height. I'm not sure what parking has.
Well, what about the habitable attic? Isn't that another bedroom?
No. Why is it a bedroom? Is your basement a bedroom?
I'm just asking you.
It's a painter studio. It's a kid's loft. It's a game room. It's a library.
Okay.
Who says it? It doesn't even have a door. How can it be a bedroom?
Just asking. a
Okay.
question. Because if you have 4 bedrooms, you need more parking, right?
I understand that.
Okay.
That's why it's not a bedroom.
Okay. So, I'm going to ask our court
Again-
reporter to mark another document as T12. Got a couple questions about this. Brasso?
And if I could ask everyone, given the travel into later in the evening, if we can ask questions and respond to them as efficiently and without excess editorialization as possible, I would appreciate it. Or badgering as
Okay, Mr. Brasso, you're looking at what's been marked as T12?
Yes, John.
That's your Zillow listing for 131 Garrett Avenue, correct?
This is something you pulled from somewhere that was created by a real estate company that I work with. I think that's what this is. I don't recognize this.
Okay. Well, it says at the bottom Caldwell Banker Homes. So is that your realtor?
No.
They're not your realtor?
No, they're not.
Why are they selling this house then?
Ask them.
Okay. Well, let's just go through the information.
No,
on
because
it.
this is invalid. It's not
you
their
answered the
listing. They
question.
can
Let's
put-
move on, please. Thank you.
You'd agree that it's listed
I don't agree to anything.
for $695,000,
Not
correct?
anymore. No, it's not. This isn't even right.
And it says it has
No,
4
no.
bedrooms.
This isn't right. This isn't my listing.
Who is your realtor for these properties?
Keller Williams.
Keller Williams.
Keller Williams.
So this, you didn't authorize this, you didn't know about this?
Already answered that. No, it's not my listing. I didn't authorize it.
You didn't
I've never
authorize
seen it before.
You weren't
Asked
aware
and
of it.
answered. Thank you.
Move
Let's
on.
move on. Let me chime in
Sorry.
once in a while.
I
I don't have any other questions for Mr. Brasso.
Mr. Danick? And just so everyone knows, if we get to 9:30 and are not finished with this witness, we will take a break.
So for the board, I had submitted the memo of law with the 11 exhibits. Can I mark this as Appellant's Exhibit 1, which is a compendium?
Can you use a microphone, please?
Sorry. Can I mark this as Appellant's Exhibit 1, which is a compendium of documents labeled 1 through 10?
Without objection.
Thank you.
Well, can I?
You want to verify that it's...
Can I look at it? Because I'm probably going to object to at least a couple of things as hearsay, if it's what was filed with the application. Okay.
With that in mind, are there...
He's referring to his briefs.
Let's go through one by one.
Well,
Let's take the break now, have 10 minutes to take a read through the materials. We'll resume at 9.
No, I just don't know the code. That's the problem. Yeah. Oh, yeah. No, absolutely. I'm not in the office. I'm not going to take advantage of it. Sorry.
What are the chances of that?
What's that?
If I could just take this set.
Oh, yeah. Oh, sure, absolutely. Yeah. Yeah, we have another set over here. Yeah. We're going to be starting promptly at 9:30, so let's reconvene, everybody.
Got to keep your energy up. Okay, we're going to reconvene. Mr. Danik.
And Mr. Brasso, I'm sure you know, but you remain under oath.
Understood.
We're going to get to this now.
Yeah.
We're going to talk about the exhibits. Yeah. Okay, hold on.
So, most of the exhibits the only exhibit I'm going to object to, exhibit, is the last one, the newspaper article. I don't see the relevance of the newspaper article being in here unless we want, when it's done, you don't. I'm going to object to 11. The rest of them, I have no objection to.
It's a newspaper article. It was published publicly, and it covers the, I guess it was the Board of Commissioners meeting where they decided to send the solicitor to this zoning hearing tonight. And I don't know that the township or anybody ever contacted the newspaper or Ms. Stein and to seek a retraction on anything. But it's being submitted for the fact that it was published publicly.
What's the relevance to it?
Well, we have, why don't you answer that question, then I'll weigh in.
Well, the relevance, one, it covers what Mr. Brasso stated to the Board of Commissioners. Two, it also has different comments from the different people, and I think it supports, which his testimony will also support, his good faith efforts to comply with the zoning code.
Okay, we have fairly wide discretion in terms of what we can admit or not admit. We're going to admit Exhibit 11 and give it whatever weight we determine to give it. Thank you.
Thank you.
Just one other issue with this document. There's a brief. And in the brief, there's a lot of facts, which nobody's testified to yet. Mr. Danik, I think, says that Mr. Brasso is going to testify to some of the facts. But I have an objection to this brief being in the record with those facts that nobody's testified to. The main issue that's in here, or at least one of them, is there's a lot of allegations and facts about financing, what his bank will do, what the impacts of that are. There's no banker here. So I got an objection to what's in this brief, which I think is an improper insertion of facts into the record.
And with respect to the brief itself, what is outlined in the brief summarizes not only the exhibits, but what Mr. Brasso is about to testify to is to his understanding of what's going to happen to the construction loan should he be forced to reconstruct the property.
And if he's going to testify to that, all these allegations that there's been no testimony, then I'll withdraw my objection. But I just want the board to be alert to, there's a lot of things that are in this brief that, including that we may not have any testimony. So.
And did the township raise that in response to the brief that was submitted by the applicant?
No.
There was no responses to either brief.
Okay, we're going to admit. We will admit the brief.
Great, thank you. David, do you have the compendium of exhibits in front of you? Okay.
Yes.
Now, I guess first and foremost, at any point in time during this project, did you ever direct Luce to violate the zoning codes?
No.
Okay, and when you start a project with Luce, your architects, can you just please explain the process?
Well, Mike and I have been working for a number of years now, so we have a pretty good process ironed out. He knows what type of buildings we build and what we expect from Luce, so a lot of it is basically copying what we've done previously. So I basically connect Mike with the site plan so he knows how big the box is in which to fit the building, and then we talk about other details like things we already know about. We always build a 3-bedroom, 2.5 bath. In some cases, we've built 4 bedrooms, 2.5 bath. Some variables like, are we going to have a garage or not? Do we have anything in terms of the site plan with steep slopes that need to be accounted for? But we've done this so many times that what we do is kind of vanilla in terms of design, he does great designs, but it's vanilla in terms of the structure of what he needs to design. So it's really a pretty smooth process. We used to have meetings, but we don't need to do them anymore. We can do it all over the phone and email at this point.
And then based upon your working relationship with Luce, you trust them to do their own research into the zoning code, correct?
Always. Mike's been excellent at that.
And since you've been a builder, I think you testified about the last 5 years you've considered well, I should say developer. Have you ever done any independent analysis of zoning codes on your own?
I give it a cursory review when I'm looking at a piece of land to see if what I think I can do will meet the code. So I look at things like setbacks, parking requirements. I look at, impervious coverage. I look at building coverage. So I look at some quick and easy things that I can calculate on graph paper, if you will, because I can't move on a piece of property if it's not going to allow me by right to build what I think I can build. So I do a very limited cursory review of some pretty simple zoning codes.
Okay. And with respect to this project, once Luce developed the set of drawings that would be submitted for the building permits, did you ever review them?
I wouldn't even know how. No.
So what did you do next once you got some drawings from Luce?
I pay the permit fee and submit them to Susan in that desk down the hall.
Okay, and when you say pay the permitting fee, how much was that?
Gary, how much was the permitting fee?
No, it has to be from your recollection.
I believe it was about $6,000 to $8,000 per side. So $12,000 to $16,000.
Okay, and did you pay any sort of professional services escrow to the township?
Absolutely.
And how much did you pay?
Too much.
No,
I
by
paid.
Just answer the question.
Right.
Sorry, I paid. I paid. I don't know how much I paid because I had to pay an initial amount and then they come back if you use up that money, they ask you for more money. So I think in total I paid $15,000, but that's for everything.
Okay, and what was your understanding of what that money was going towards?
Well, a lot of it went to the site plan because they had two different engineering firms look at my site plan, and I basically paid for that twice because they got rid of one in the middle, and then the other one had to pick it up. And so I paid for all those engineering reviews of stormwater management, of parking and grading foundation. I'm not sure what else they do in that process, but it's a lot of engineering. How you connect to the sewer, how you get your utilities in there. So that all gets taken care of as part of land development. And then you have the other review, which is, I guess, what they ultimately farm out to Keystone for their review. And then you have some legal for other things, and some administrative for the folks back there. So it's all in that $15,000.
Okay, so just so I understand, of that $15,000 that you had paid, part of that was paying for the township's own representatives to review your plans for zoning compliance, correct?
Absolutely, yes.
Okay. And after the drawings were submitted, about how long did it take for you to get a response?
I think they give you a response within 2 or 3 weeks, Mark.
So if you turn to Exhibit 5 of the compendium, and I'll represent to you that Exhibit 5 is simply an excerpt of the set of drawings that we got back marked up. And can you read on the second page the handwritten notes?
Applicant copy, something, something, approved as noted. I can't make out the rest.
Right. Yeah, it's no copy was good. I did the best I can. But based upon these comments on the drawings that you received back after the review, you believed everything was compliant and you were ready to move forward, correct?
Absolutely. Yes.
Now, once the set of drawings are approved, what do you do next?
Once the drawings are approved, you have to post your escrow for, in the event that I can't complete the project due to death or some other fate, that the township can pick it up and clean up the project. So we had about a $40,000 escrow for the stormwater management system. The whole escrow was about $75,000. So you have to pay that in cash, and the township holds on to it and makes sure you do what you're supposed to do. And then once they fund the escrow, I think then they give you the actual go-ahead to break ground and start building. I think that's the process.
Okay, and then once that's done, did you do anything to start construction on the buildings?
No, I don't do anything. I give it to Gary of Diamond Construction, and then Gary does the initial engineering of laying out where the building's going to go, and then he brings in excavation equipment to grade the site and prepare it to dig foundations and then pour concrete.
Did you have any involvement with ordering a lumber plan?
No.
And
I just write the checks.
But what's your understanding of a lumber plan?
Guy write whatever. I mean, Gary tells me how much it's going to cost, and I write the check to pay for the lumber.
Do you know what the lumber plan is for?
For the beams and the plywood and the other things you need to construct the house.
So do you know if it's pre-engineered?
A lot of it is, yeah, definitely.
And it's based upon the drawings that were approved?
Absolutely.
Okay. And at the point that I guess Gary was ordering the lumber plan, did he give you any cost estimates?
Yeah, I mean, Gary and not cost estimates per se, but Gary and I talked about it. Sometimes he comes and says, look, this building's going to be a little bit more expensive to build because you have to carry load and across certain spans, and in order to do that, Luce has designed more engineered lumber, which is more expensive. So I think in this case, the building framing plan was a little bit on the expensive side because the building was wider than 20 feet and pretty deep. So we had to use a lot of expensive engineered lumber that can carry a higher load.
Okay, and do you recall the cost of the lumber?
I'd be guessing, Mark, but I mean, the lumber.
If you don't know, you can't answer. If you do know, answer.
I know within a range. I can tell you it was at least 40 and probably less than 80.
Okay.
Per side.
When you say per side, is it per 131 and
Yes.
the other 133?
Yes.
So it's around 80,000 total?
On the low end.
Okay.
Yeah.
Now, once the lumber plan is in place, what do you do next?
Again, I don't do anything. At that point, I turn the whole thing over to Gary, and Gary calls me when he has a question, and he tells me when I need to make selections. Things like what color do you want the siding and the shingles, and how do you want to handle this. But at that point, Gary runs the show. It's why I hire him. I trust him.
Okay, and do you have a approximation about how much the work that Gary would be doing at this time for construction and site work would cost?
I'm not sure. What can you rephrase that, Mark? I'm not sure what the question is.
Well, I guess the question is, what we're trying to figure out generally is your what you've incurred financially from the date that the drawings were approved till the date that you actually received a cease and desist notice or an enforcement
On
notice
June
from the
6th?
town. Correct. So right now, in the immediate time period after the drawings were approved, you've ordered the lumber plan, now you're moving forward with construction, and I want to know what happens next.
Yeah, so I don't know if you wanted to include this, but the land purchase was $200,000, and then you have engineering and architectural was another nearly $50,000 on this. Then you have 15 for the township review process. You have legal bills that were maybe another 5 to 10. But then the actual construction work, we were probably on an $800,000 loan. We were probably 45% of the way through, so we were probably around $375,000 into that loan based on the draws.
And what time period are you referring to?
From the date of the permit issue, well, from the date of permit issuance. Well, from when Gary broke ground, right? So in November, when he broke ground until June, I believe we spent about $375,000 on construction. I'd have to check the figures, but I think that's pretty close.
Okay, in February of 2019, how far along was the project?
A lot of the expense is getting the buildings out of the ground. That's what Gary always says, is once you get out of the ground, then you're pretty safe for the most part. So getting it out of the ground and then getting it framed was probably, it was at least $250,000, not including the land. Yeah, again, you're asking just construction costs, right? You're not asking
Correct.
for soft costs? Yeah.
Right.
Hard construction costs was at least $250,000.
Were you at the site observing the properties as they were being built?
Yeah, I go by nearly every other day to
And-
see what's going on.
And did you ever confirm that what your contractor was building was in line with the approved drawings?
Yes, Gary always builds exactly to the drawing. If there's anything different, he calls me in to talk about it.
And do you recall the approximate time period when, I guess, the township first notified you of a potential problem with the height of the structures?
Well, I think it was in the February timeframe, right? Late February.
Okay, so in February, at this point in time, was there any specific, say, stop work order or cease and desist order issued?
There was no official stop work order. I think we stopped work for a day or half a day, but we were never told to stop working on it. And if we were officially told to stop working, we would have stopped working.
Okay, so at this point in time, after you've been notified that there was a potential issue with the height, what did you then do?
I wrote to council and other folks that I think are knowledgeable in this area and said, what happens in the event that a permit's issued and then there's something in the permit that might have been inadvertently issued. I didn't understand the law or what the precedent is. So I wanted to educate myself on just a general matter of law. But I believe we had some discussions, you and I. I had discussions with Mike about what he designed. And then we came into the meeting with, I think Kevin was there, I know Bob Z was there, and talked about the fact that there could possibly be an issue with the building.
And when was that meeting?
I think that was early March.
Okay, and do you recall a meeting, I guess, late April regarding the height issue?
Well, we had a second meeting after the Radnor Township hired Yerkes, or I'm not sure how you pronounce that engineering firm. Mr. Rice was out, and so he sent someone from his office, so they were represented. You were there. I don't think Gary was there. But it was generally around the discussion of what to do about the building height and how to quell the situation, either make it compliant or do something to mollify the situation. That's the way I interpret it.
Okay, and I guess the Yerkes memo and the meeting, is that referenced at Exhibit 6 of the compendium? And for the record, it's a April 23rd, 2019 email from Steve Norcini to DJB Properties and several other people.
Yeah, I remember being a little bit shocked by this Yerkes memo because of point number 2, which they then they agreed that there wasn't an issue with number 2. So I
When
guess
you
they-
say point number 2, you're referring to the impervious coverage?
yes.
And that even though Yerkes apparently had found that to also be in violation of the zoning code, it actually, your approval and what was built was actually matches your 2016 land development approval with the Saldo waiver, correct?
Yeah, I mean, look, I found this upsetting because here we are, somebody's paying for Yerkes to come in and assess what's going on. And either through their own negligence or they just weren't given the true set of the facts, right? So if Yerkes is being hired to assess what's going on in this building, wouldn't they have been given all of the documents and approvals up to that point to know that we were given an impervious variance that would, like, we weren't we didn't have an impervious situation. So it made me question how much Yerkes really knew about this project, because they didn't know some pretty important things.
Okay, and with respect to, I guess it's paragraph 5 of the Yerkes memo, it states, the building construction plans document a proposed building height of 29 feet 5.5 inches, which has been calculated per zoning ordinance, Article 1, General Provisions, Section 280-4.b, building height, and is in compliance with the district maximum allowable height of 30 feet. When you read that, did you have any reaction?
Even reading it now, I'm not quite sure I understand it. It looks like they don't think that there's a building height problem.
Well, at least as measured pursuant to 280-4B, correct? Which is the general height calculation.
Is that what that means? Yeah, then now I understand it. Yeah, and if you were to measure this building basically anywhere else in Radnor, the way they measure it, which we determined is to the midpoint of the roof, as measured from the top of the roof to the bottom of the roof, this would comply within the 30 feet maximum height allowable. So yes, if that's what that says, then yeah, I agree with that. And it looks like Yerkes agrees with it too.
Okay, and then going back to the first page of the email, it says, at this time, all work on the project must cease until a plan of action to rectify the height compliance and impervious coverage issues is submitted to the township for review. Now, prior to this April 23rd email, had you received any sort of cease and desist notice from the township?
No, or we would have stopped.
Right. And you continue to work, correct?
Well, we stopped when we got this memo until we were told we can continue again.
Right.
So I think there was a day and a half in there.
Okay, and when you say you were told to continue, is that email referenced at Exhibit 7 in the compendium?
It appears that it is, yes.
Okay, and this is an April 30th, 2019 email from Steve Norsini to Dave Brasso and myself, amongst others. And this was an email, I believe, generated after our meeting, I believe, per today's meeting. So we met on April 30th. So then at this point, now that you've been given the okay to continue work at the site, what did you do?
We continued. We had scheduled a meet, as we discussed earlier, so we continued.
Okay. Did you submit any plans that showed a height difference of 2 feet?
Yes, I took the drawings from Loose Architects that showed a new roof structure, which they believed would be structurally sound and would work within the existing framing that was already in place. I didn't truly understand the difficulty of it, that, as Gary mentioned earlier, with bringing in cranes with some of the engineered beams we'd need. But to me, I was more concerned about, could it be done and what would it look like? So Mike designed a very pretty roof, a very appealing roof. It was indeed lowered 2 feet, 24 inches. It looked good to me.
The 2 feet or the 24 inches, that was your understanding of what the township was requiring to at least come into compliance?
Objection, it's a leading question.
Well, rephrase it.
Well, yeah, so you had referenced the attached design says to lower by 24 inches, correct?
Correct.
And
English standard units of measurement, 2 feet equals 24 inches. So
correct.
I thought
but
we
at that
complied.
point, the 2 feet is your understanding of what the township was looking for.
Yeah,
correct?
so let's review, because this is really important. So we get called into a meeting. We all stop our days. I get my architect there. I get my attorney there. Everyone comes in to this building upstairs, and we talk about this rationally. And after going around and around with everybody, they said, well, look, come back and show us a plan where you can lower the feet at a minimum of 2 feet, right? And then they document it in this email. So that's our marching orders. So we take this email, and I talked to Mike Gerard, and I said, Mike, give us a plan. Mike takes his time. He looks at all the load-bearing calculated, the engineered lumber and all that. He gets back to us in a couple of days, pretty quickly. He turns this around, gives us a beautiful drawing that shows how we can lower the height. You know, logistically, I don't know how it's going to work with Gary and the schedule, but at least we have a plan. And we submit it through the channels for approval, and then I still don't understand why it got rejected, but it got rejected.
Okay, and when did you receive notice that your proposal of May 3rd was rejected?
Well, after May 3rd, so I guess within 2 weeks of May 3rd, Mark. I don't recall the exact time frame.
So if you would turn to Exhibit 9 on the second page of the email chain.
Yeah. So here it is, May 20th. So it's 3
No,
weeks.
the second page,
Oh.
May 13th.
No, there's... Oh, okay, yeah, you're right. So there's 2 emails. So, yeah, May 13th, they said that the current proposal falls short of the manager's expectations, which I really didn't understand because 24 inches equals 2 feet. So I thought we met what was documented in the prior email, and we were compliant. I didn't understand how it fell short of the manager's expectations.
Okay. And did you have a subsequent proposal that you submitted?
Yeah, because, okay, so not to get in the weeds, but it seems we must. The roof height is a factor of 2 things, how high the roof is, but it's also how high the dirt is around the building. So one way you can artificially lower the measured roof height is to raise the height of the dirt around the building. So on this picture, I don't know if you guys see it, but we proposed building a retaining wall in the front of the building and raising the dirt up a couple of feet so that the height measurement would not be taken from the sidewalk elevation, but from a higher elevation to the roof. So effectively, you're lowering the roof height without even really changing the roof. It's kind of a back-end way to lower the roof height, but it was one of the things Yerkes had asked us to consider. So my proposal back to them mentioned perhaps bringing that front elevation up. I even did a drawing of it in section 9. I don't know that they ever really gave a response to that drawing.
Well, if you look at the email directly above, is that the response?
Well, they didn't say that they didn't like that plan. They just said that the roof line should be further lowered. But, you know, we talked with Mike and Gary, and we didn't know of a way to bring the roof lower. And as you lower the roof, you become non-compliant with the minimum roof pitch in the GHN district. So how do we comply with one violation by violating another violation? So as you lower the roof by flattening it, now you're in violation of the roof pitch. So I didn't know how, I didn't see a way where we could possibly lower the roof more than 2 feet without, as Gary said, basically destroying the building and bringing it down. You'd have to cut off the attic and the second floor in order to make it work. You'd have to go all the way down to the first floor and build it up from there.
Okay, and if you are required to remove the roof and make it become compliant with the Garrett Hill zoning district, what is your understanding of what may happen to your construction loans for this project?
Well, I have a personal guarantee on this loan, so that means that the bank is saying that if this project goes in a bad direction.
Right. It has.
No, that is a personal guarantee.
Well,
That's a
no,
definition of
David,
personal guarantee.
the question, his objection relates to, you can only testify to your understanding of what's going to happen at the bank. You can't testify to what the bank tells you. Okay, so it has to be your understanding of what's going to happen if you're required.
Stop me if I'm out of bounds, but I signed a personal guarantee on the loan, which means I'm backing this project financially, right? So I borrow $800,000 from the bank to build this project. It's based on, I had to submit those approved plans to the bank. They, by law, after 2008, they have to perform a third-party appraisal, has to appraise the building and say it's worth what it's worth. But the appraisal is based on that plan. So if anything in that plan changes, then my appraisal is no longer valid.
But
and
when you
my
say that
loans-
plan, the bank is relying
On the approved plan.
On the approved plan from
on
the
the approved
township, correct?
architectural plan, not the site plan. They really don't care about that. They care about the architectural construction drawings. If they're changed, then I need another appraisal because I could be out of the bank's covenants for the loan and I could be in default of the loan. So they could effectively call the loan.
And when you say call the loan, what does that mean?
That means they ask for whatever money I spent to date back in a check within a time frame. So at that point, it would have been probably close to $400,000.
And when you say $400,000, is that the total amount that's been paid out so far under the loan?
That's how deep I am in with the bank at this point when you include the escrow amounts.
Okay, with respect to 131 and 133, is either property ready for occupancy?
I don't know which number is which house because we haven't been given addresses from the post office, but if we assume the left side is 131, then I will say that the left side is pretty close to ready for completion. We would need a CO from Radnor Township, which this weighs pretty heavily on that. But after that, most of the construction is completed.
And do you happen to know, like in a ballpark range, how much you've spent just on, well, I guess the project, getting 131 to its point of completion, as you just stated?
Yeah, I mean, it's hard to say because the numbers blend, but to build 131, if it were just a single unit to this degree, would have cost $350,000.
Okay, and with respect to 133, do you know approximately how much you'd have to spend to complete that structure?
I'm going to guess, Mark, but I think it's probably another
Well, you can't guess.
Oh.
You have to give us numbers.
Okay.
Or at least provide a basis
Based
for
on
your estimate.
my knowledge of the budget, I believe it's about $150,000 to complete it. Might be $125,000. So it's somewhere in that range.
Okay, and do you have any idea what cost would be incurred if you're required to remove the roof and make it compliant?
First of all, I don't physically know how we would do that. It would be effectively destroying the building because to take the entire roof off, you're going to get hit with inclement weather, which is going to destroy the inside of the building. I don't know how I would have a contract. I have a contractor's guarantee. I don't know. That would go out the door. Gary, once this thing changes, I don't even know if Gary would build it. It would be a mess.
Well, do you have any idea how much it would cost in materials and labor to lower the roof?
Well, Gary and I are in agreement that lowering the roof is not just a simple task of lowering or flattening a roof, okay? If you flatten a roof over that span, it'll collapse. You can't just do that. So when you say lower the roof, you're talking about taking the whole roof and keeping the pitch, but pushing it downward, which basically means destroying the second level of the house. So you would have to rip off, you'd have to almost start from scratch. You could keep the first floor of the building. That's it. You'd have to build the rest from the ground up.
Okay, and do you have any estimate as far as if there are any potential damages to this structure if you have to remove the roof and rain gets in?
I think it would destroy the building because it's going to take on, you're not going to be able to control the amount of water that gets taken on.
But my question is, if you have to spend money to repair a damaged structure, what is the potential exposure you may have if the structure is damaged?
You'd have to probably, you'd have to replace the HVAC system. You'd have to replace the drywall, the insulation. You'd probably have to replace all the lights.
Can we get a number, please?
I think it would be north of
if you don't know,
north
then
of
you don't
300
know.
north of 300,000.
Okay.
Yeah,
And would
sorry.
there be any added insurance cost if you had to insure the uninhabitable property?
Well, insurance is a good question. Right now, I'm insured on this property for builder's risk. I don't know what would happen there. I don't know what kind of insurance I would have. If this house was deemed an attractive nuisance, I'd probably need another policy for that. I'd have to consult my insurance agent. But it would be more difficult than it is today to insure it.
I guess, and lastly, David, before the tab 1 is a legal memo that I drafted.
Mm-hmm.
And have you had a chance to read that memo?
I did when you, yes.
Okay.
I did read
and
it.
recognizing that this was drafted by me, do you adopt the statements and factual representations in the memo as if it's your own?
I do.
I'm going to grant that one.
Thank you. No further questions?
Mr. Rice?
Excuse me, Mr. Chairman. Perhaps to stage out the balance of the evening, is it possible to ask both sides what additional witnesses they may have left in terms of present?
Good. Asked that an hour ago. Any follow-up questions, Mr. Rice?
Mr. Brasso, the bank, testify about what the bank, no, Kevin took it away. Mr. Brasso,
It's the microphone.
you testified regarding the risk that you would have with your lender if you had to make some change to the building. Did you actually run this by your lender, or is this just your understanding?
The lender is my first call when I get out of this meeting. They are aware of the situation and monitoring very, very closely.
Wait a minute. They're your first call after tonight? You're going to call them?
Well, I'll probably call my wife. But, yeah, I have a fiduciary duty to tell the bank what transpired tonight.
Okay, but you haven't asked them yet. They haven't given you a written document saying if you have to lower the roof, you're going to violate the bank covenants. You don't have anything from them yet because you haven't told them what the result of this is going to be.
I signed some pretty onerous documents that stipulate what the covenants are. So I don't
Okay.
need them to tell me that. They're written in the
Okay,
document.
that's all I want to know, whether
Yeah.
they actually sent you some letter or, what the risk would be if you changed the architectural plans. That hasn't happened. That's all I want to know.
They have not prospectively written me any nasty grams telling me what could happen, no.
And then the other thing is about the listing. The other thing is about the listing for this house. You testified previously. I mean, I had shown you a listing. You said it wasn't your listing. It's listed with Keller Williams. Is that Michael Soroka with Keller Williams? Is that who it's listed with?
Michael is the agent of record.
Okay, so here's his listing.
Mm-hmm.
Same price, 4 bedrooms, 3 baths. Did you authorize him to list that for you?
This is out of date. This is not accurate.
Okay, well, let's mark that one then.
I
too.
do, here's what I'll say. I have an agreement, a contract with Mike Soroka, of Keller Williams, to represent this property. I'm not aware of every detail on how he listed it, but that
Okay.
price isn't even accurate.
Okay, can we mark this then as T13? Okay, so this is also accurate, as is the other one. That's your testimony, correct?
Can I see it again? I know that we lowered the price. I haven't seen anything else to prove. I know these pictures are accurate. I don't know how it's written up. I mean, I could look at it. So I cannot tell you that everything's accurate. It says here it's 4-bedroom property, so I know that's not right. Sometimes realtors will do things to stimulate demand in a property, and they're not factual. So they do this stuff all the time to try to get appointments. That it's not uncommon for them to use puffery, if we will, in a given domicile to attract
So
suitors.
that's your next call after the banker and your wife. You're going to call the realtor after tonight. Is that-
Mr. Rice, please.
I have no further questions.
Mike can market the property how Mike wants to. I'll talk to him about it. But you know.
I just have one follow-up.
Quickly, please.
Did you notify your lender that there's an issue with the Garrett Avenue properties?
I've spoken to John Pergolin, who's my
The name again?
John Pergolin, Pergolin,
And
he's my representative at DMB, and we have discussed this. So
Okay,
yes.
and when's the first time you notified him of this problem?
I don't know.
Was it a month ago?
I'm sure it was when we got the cease and desist order on June 6th.
Okay. No further questions.
Are there any questions from any of the additional parties to the proceeding? Ms. Barker?
Hi, David.
Hi, Patty.
So my recollection is that you and I first met in June
Ma'am,
of 20...
you can't testify as to your recollection.
Oh,
You can
sorry,
ask him
sorry.
questions.
Okay. Do you remember meeting me in June of 2015 after the Planning Commission meeting?
In this building, yes. I think we
Yeah.
spoke, yes.
And do you remember our conversation and you offered to come to a Garrett Hill Coalition meeting to share your plans with us?
I did.
Do you remember at that meeting that we presented you with copies of the Garrett Hill Zoning District ordinances? You did show us a plan that had the garages in the front, and we did express our concerns. Do you remember agreeing that you would go back and rework the plans?
Of course, we removed the garages, yes.
You then came back in January of 2016 with this plan. This
T6. We presented T6 as an attempt to
Okay.
appease what you had objections with on the first
Let
plan.
Ms. Barker ask her question, please.
All right. So my question is, I'm not sure how to phrase this as a question. Based on that meeting, we felt that this was the plan you were going to present.
Justifying again.
I know, and I'm sorry. Do you remember I came to the Planning Commission meeting in March of 2017?
I think you came to a meeting where you were
Anyway.
in support of what we were doing. If that's the
So-
meeting you're talking to, then yes.
My question is, what happened between January of 2016, March of 2017, and August of 2018? How come you never reached out to the community again when you had reached out to us originally? Knowing full well that the community felt very
Ma'am,
strong.
you don't-
Sorry,
you don't
sorry,
know.
sorry. That's right, you're right. Thank you.
Okay. I was remiss. I wasn't asked to meet with you guys or invited to meet with you. Look, Patty, I'll go to my grave saying this and believing this, that I don't think that plan that you see in front of you is in any appreciable way different than the one we actually built. I
It's
think it's
lower.
cosmetically different. The building height on that plan isn't even different than the one that we built. If I thought we were changing something material that you would object to, why would I was currying support from you guys, and I wanted your involvement along the way. There's an email from John Childs that says, Mr. Brasso, unlike other developers, has solicited the support of the Garrett Coalition. Like, I was shocked when you guys came out raging against this project. To the day, I can't understand why you're not in favor of it. I think it's a beautiful house, but I also believe it's not different from what you see there in any meaningful way.
Okay, the question's been answered. Thank you.
Yeah. Thank you very much.
I'm sorry, but that I didn't.
Thank you.
I should have.
Are there any other questions from any other of the additional parties?
I'm Nancy Nancy Limelind. I have a simple question. I wanted to ask Dave and his architect if they reviewed the special regulations for the Garrett Hill zoning district. They basically govern parking, driveways, approaches, and the rules that manage them.
I was aware of some of the things that we had to comply to get through land development, such as parking requirements and setbacks and things of that nature. Once we passed that hurdle and it went to construction drawings, I literally turned everything over to the good folks at Luce because I don't understand the building codes. They're very difficult. They're dense. There's a lot more involved than a layperson can understand. And in this case, I think it's a difficult interpretive measure as to how to measure the building height. Unless you're intimately familiar with this exact code, I can see how you can make a mistake.
You've answered the
I
question.
just then wonder.
I'm sorry, I didn't. I trusted Mike. I didn't.
So do you realize that multiple listing agents list this property at various prices with 4 bedrooms and 2.5 or 3 baths?
But I mean, I'll answer it. I
Fine. Why did you add a 3rd story, which is not apparent in the plan that the community saw and agreed to?
We don't have a third. This is never considered a 3rd story by anyone who measures things by those.
Except the
Hold on,
people that are
because it's a semantic difference, but it is important. This house, as built and as approved, is 2 stories with a habitable attic. It's not a 3-story building. I know that's semantic, but it definitely means something.
As a person, okay, never mind. I can't say.
But that's how we describe it in the profession, as it's a 2-story building with a habitable attic.
Do you understand that the 30-foot height of roof was basically designed to prevent 3-story buildings in an area where there are none, just about?
No, and I don't understand why that would be the case. In fact, when I walk up and down that street, I can see buildings that have habitable attics in them. So I don't know why this building with a habitable attic is so objectionable.
Are there any other questions that cover new ground on this issue?
Your name, please?
My name is Dee Delaney. I live at 229 Williams Road. So I have a question for you, Mr. Brasso.
Sure.
Knowing what you know now, would you have done anything differently as far as checking for yourself or educating yourself more about zoning codes?
Dee, I love you for asking that question.
Yeah.
Thank you. Knowing what I do now,
Yeah.
I would have never bought this property. I would have never attempted to build in this zone, knowing how difficult it is and knowing that there's pitfalls that I couldn't predict and was unaware of. I would have never taken on this amount of risk and headache. I would have passed on this whole project. I was trying to do something that I thought would be a benefit to the street. At the same time, try to, as a businessman, make a few dollars, but I was trying to enhance the architecture of the street. I'm being viewed as a villain, but I was trying to help out here and do the right thing. I would have walked from it. I would have ran from this project.
Okay,
I can't get out of it.
I have one other question follow-up to
Quickly.
that. Yes. Do you remember in July, following the Board of Commissioners meeting outside with Patty Barker and a few other people, stating that you were warned ahead of time by Radnor Township officials not to build here, that it was too restrictive, too hard? Do you remember that?
I do. I think Kevin you and I might have had that discussion, and you said, just be careful. You know, consult with the people in the town, because they're very, very vocal.
Okay, you've answered the question. Thank you. Questions from the board for this witness?
Yeah. You indicated in response to the question about how you get into a project and what your nature of review, that the phrase you used was a cursory review, and you look at the setbacks and the coverage areas and whatnot. And I assume that's at some level so that you can do the roughest estimate of whether it makes sense, the land acquisition makes sense, because you have an idea how to build those numbers up, right?
Yes, and in addition.
Okay, thank you. Obviously, there's an entirely different assessment of a two-story building from a six-story building. And that kind of assessment that you're talking about must involve making a determination, because you also said you want to know what you can do by right. That was part of your testimony.
Absolutely, yes.
And you've developed enough buildings that you know one of the considerations of by right is how high you can build. So when you were acquiring the property, how high did you think you could build?
Well, Mike and I talked about this all along the way. I mean, that drawing right there, you know, I view that as 2 stories and a habitable attic.
No. If you're looking at setbacks,
Right.
you're not kind of saying, the distance of a mid-sized garage. You're saying 8 feet, 10 feet, coverage levels, 60%, 80%. If you're looking at a height, you're not saying, I bet I could build 2.5 stories there. You're saying it's 30 feet, it's 36 feet, it's 40 feet, it's 28 feet.
I don't mean to be, it's not that simple of a question. Like a 25-foot setback is pretty clear. It's 25 feet, don't build any closer than 25 feet.
And the height, I'm not asking the interpretation of what you thought the limit was. I'm asking what you thought the limit was.
We thought up until somewhere around June 6th, that the limitation was that your roof could not be higher, the midpoint of your roof could not be higher than 30 feet. We thought that all along. I mean, Mike designed it that way, we submitted it that way. I always believed it was that way until Kevin pointed out to me that there's a special way to measure the roof in Garrett Hill that's different.
The timeline really doesn't hold together, though, because that initial assessment is the one you're making early on before you get involved with your architects and your lawyers and whatnot. I mean, when you were initially looking to acquire the parcel, I mean, you previously said you didn't know anything about the peak of the roof and the midpoint and all that. It's just,
Right.
you let these guys deal with it. So what was in your head in terms of how high you could build at that location?
I never, what was in my head is we build to the maximum allowable space to maximize the livable space within that footprint and still stay by right. That's what I tasked Mike to do.
Okay, but so how are you figuring out what you can afford to pay for the land? You have to have a square footage concept. I'm going to build X square
So
feet.
it's a great question. When I initially thought that I could pay $200,000 for this land, I thought I could build a twin house and rent it out to Villanova students. I was told very early on that that was not a good plan. So my initial plan.
You got good advice there.
Yeah, but you got to understand, like my initial, this was go back to 2015. So this plan has gone like this, and at some point I should have cut bait.
Yeah.
But
Okay,
you,
I mean,
you don't always know.
I
wish I had that
appreciate-
crystal
I
ball.
appreciate your answer. After you had the meeting in late February with the community, where everybody said you can't build that high, and you also said that you're at the project a couple times a week to monitor how things are going. Did you look around and think, why is everything shorter than what I'm building?
Actually, if you were to go up and down that street,
Oh, I go up and down that street.
I don't believe that this building is higher, I don't believe it's higher than some of the other buildings there.
Please.
I see a lot of buildings that have 2 floors and a habitable attic. There's 2 floors and then a dormer up top. They're basically the same structure. I mean, if I had a 6-story building, I'd be like, oh my gosh, this is just garish and horrible, and it's detracting from the
we're
street.
not, but again, we're not talking about the aesthetics of the building. So there was nothing about that late February meeting that caused you to pause to think, we got a real problem here, because I framed this out and it's 5 or 6 feet higher than all its neighbors?
Okay, so it's a great question. So at that point, you're going through your decision tree, right? And you're saying, somebody's not happy with this building. I don't know if they're right or I'm right. Now, you remember, I still have,
And right there,
I still have a permit.
Stop, right there. Don't you call your lawyers up?
I did. And I said, what's the case here? And they said,
Don't tell us what your lawyers said. Yeah. Okay, so you did call your lawyers. Thank
I
you.
did call my lawyer.
Thank you. All right.
More than one lawyer.
Okay.
Okay.
All right.
Can I tell you my belief then?
Last question. After June 6th with the enforcement notice, was there any more work done on the site?
Indeed, there was, yeah, because we were told we could continue to work.
No,
in
no.
an email.
You were told in a memo in May that you could continue the work. And then on June 6th, you received an enforcement notice, and the enforcement notice says,
It basically says either fix it or appeal. That's what it says.
Yeah,
Okay.
so we appealed.
All
So
right.
we followed the
All right.
MPC guidelines and we appealed, which kicks the can down the road a little bit.
thank you.
All along, we're trying to just follow the rules here.
Any other questions from the board? Okay, thank you.
What do you want me to do?
Thank you.
Three of the parties who asked, entered their appearance tonight, handed me, they have letters that they wrote. So I marked them, you know, R1, R2, and R3. And, oh, R4? Okay. Mr. Danick, if you want to look at these are, R1 would be the letter from Rick Barker, R2 would be the letter from Patty Barker, R3 would be a letter from Nancy Line 1, and R4 would be from Frankie, but this person's not here. You want to mark this as R4? Okay.
Just the only, say, general objection I would have is that to the extent it's irrelevant to the issues before the board, I would just ask that you only focus. I'm sorry, I would just ask that the board focus only on the points of the letters that may be relevant to tonight's application and not any other random things that might be said in there.
Any objection, Mr. Rice?
No.
We'll admit them.
Thank you.
Okay. You're finished? Mr. Danick?
Yes, we rest, and I will not move all my efforts to the record.
Mr. Rice? Without objection. Would any member of the public like to speak on the issues that are before us this evening with respect to the application? Seeing none, we'll entertain an argument first from the township and then from Mr. Danick.
As said at the outset, the township, you know, has a burden of proof to proceed with an enforcement notice under the MPC. I think this is a permit issued in our case. You have a brief with many other legal theories from the applicant here. All of those usually deal with municipal acquiescence or somebody telling somebody at the township that they're doing something illegal. usually doesn't involve a permit that's been issued. So this falls squarely on the Petrosky case, which has been the law in this state since the late 70s. It's a Pennsylvania Supreme Court case. And I think that the two areas, actually maybe more than two areas, because I'm not sure the substantial unrecoverable sums that have been testified to is substantial. But I think there's a good faith issue here where the applicant falls short. I think to some extent, this plan, T6, that was presented to the neighborhood group, was switched later without any notice to them. He obviously knew that they were interested in the building that was going up. And, you know, and he proceeded to build it when he knew there was a problem. As Mr. Martin said, in February, late February, we saw photographs of what the condition of the building was. He could have stopped. We have notes from his architect in early March saying, I have a permit, I'm building. They haven't given me a formal notice. So I think there's a substantial burden on him and his architect who submitted the plans, which were in error. And to suggest that the township's website is the problem is ludicrous. Mr. Kachansky went through, I go through that website all the time, and I'm sure you all go on the website, you click on the zoning code, you click on the zoning district, and you read through it. I don't know how they could have missed that. I just think they went to one section. I don't think they read the rest of the section in the end of the Garrett Hill. There's a whole set of extra design criteria regarding parking. I don't think they read those either. But, you know, they made a mistake, the township made a mistake, they issued the permit in error. I think the good faith of this applicant needs to be questioned by this board. I don't know that he's expended substantial unrecoverable sums. Mr. Danik has in his brief a whole series of possible substantial unrecoverable sums, but the cost in there to drop the roof is only $50,000. The rest of it is not going to be impacted. It's just a question of how far is this board willing to go to have this roof drop? Is it 5 feet? Is it 4 feet? Is it 3 feet? Is it 2 feet? Is it 5 feet, 4 inches?
Mr. Rice, is it your suggestion that that's our job, to find the magic number?
No, I'm not. I mean, you know, what you've been asked by the applicant is to overturn the township's notice of violation and affirm that they have a legitimate permit and they can move forward with completing this project. That under all the theories that are in the applicant's brief, either a traditional variance, equitable estoppel, estoppel by variance, I think it's a Petrosky case, and that's it. You know, so they've got to meet the 5 elements, and if you find it don't meet any one of those, this is not an inexperienced developer. We heard that he's only been doing it for 5 years, and then we heard he's been doing it for 12 years, and then his builder says they've been together for 15 years. So maybe he was doing it on the side for a few years, but he's charged with reading the books like the rest of us are. And his architect is charged with reading the books and reading the zoning ordinance. So the township's position is they don't meet the good faith standard in that case or the substantial unrecoverable sums in that case. And there's sufficient evidence and testimony to support that, and there's really no clear testimony what's unrecoverable. He's listing these properties, well, maybe after tonight, not for $695, maybe for $650, but it's about a $1.2 to $1.4 million project if he sells them both for what he thinks he can get for them. So there's money to be recovered because of the error in the sale of this property. He may not make as much money as he is expecting to, but it's still a $1.2 to $1.4 million project. So that's the township's position. That's the controlling case on this, and we don't think that he meets the standard for this board to reverse the zoning hearing, the zoning officer's violation notice. Thank you for your patience.
Thank you. Mr. Danik?
Well, I would like to thank the board and everybody for coming out tonight. I do agree with Mr. Rice that this really does all turn on whether or not you believe Mr. Barrasso exhibited good faith throughout the process. I don't think there's anything in the record establishing that he had any malicious intent or ill will. At all points in time, he relied on his professionals to prepare a set of drawings. That's what he delegated them to do, and that's what he relied on them to do. There's no evidence that he affirmatively told anybody to violate any zoning code. With respect to substantial and recoverable funds, any money that he may need to spend to correct the problem is going to be unrecoverable. Whether he sells it for 1.2 or 2.8 million, the 50, 60, 70,000 or whatever the number may be to correct the roof, he's never going to see that money back again. It's money out the door. In my brief, I cited to numerous legal theories. If you look at page 24 of the brief, I rely on for variance by estoppel. That is an equitable theory where it's dependent on the township actually making some sort of affirmative act, such as granting a building permit, which would reasonably lead a property owner to conclude that the proposed use was sanctioned under the law. So while I think the township's decision could be overturned under any number of theories, I do think you would focus on the variance by estoppel because that is an equitable theory. It's akin to a justifiable reliance theory in that he turned his drawings over to the township. He paid the township for their own engineering review and zoning review. He relied on the process, and he paid the township for the review. They came back and said, you know what, you're compliant on September 11th of 18. You're compliant. Go ahead. Based upon those representations, he then, the train left the building. He was not going to be able to stop. He had to keep moving forward. And, he got to the point where he is today because he had to keep the project moving. There was no official cease and desist or stop work order until the June notification. So any stoppage of work prior to that would have been premature on his part. If the township really believed that there was a solid issue here, back in February, they could have issued their enforcement notice. They didn't. They waited 4 more months. And along the way, Mr. Barrasso continued to construct his project in good faith to what he believed was the correct measurement for the roof. And based upon the testimony here tonight, I would hope that the board agrees with us that Mr. Barrasso exhibited the good faith necessary to overturn the township's decision. Thank you.
Thank you, Mr. Demick. Any comments from any of the additional parties to the proceeding? Seeing none. Seeing one.
I would like to thank you for your consideration and for your service.
Always suck up to the board. That never hurts. Okay, with that cogent conclusion to the argument, I will ask for a motion to get discussion started, if anyone cares to toss one out.
I move that we confirm the enforcement notice.
Is there a second? All right. Is there another motion that we might consider?
I'll make a motion that we accept the applicant's request to overturn the enforcement notice based on a theory of variance by estoppel.
Is there a second?
I'll second it.
Okay, now we have something to talk about. Who would like to start?
Procedurally, is it inappropriate? I actually wanted to ask council a question on this issue that's been raised. It's something that we can receive further comment on?
From the party?
From council for the parties.
Go ahead, Rich.
So, and it doesn't matter to me who who starts, but I'm curious to hear argument on Scarvellis, which is the estoppel case, versus the Shuey case that the township cites in its brief. If you can, they seem to fit together, but not cleanly.
And you know, the township is not arguing variance by estoppel, so we'll let the applicant make the argument if they care to respond.
Well, beginning on page 18 of the brief, that's where there's.
I'm
Well,
sorry,
right.
not everyone has the brief, so let's
Okay.
talk conceptually.
Well, just conceptually, beginning at page 18 is where I discuss the equitable theories that are based in the common law, which is judge-based, that allow this board, which you are the trial court in this instance, to essentially say, you know what, he may not have strictly complied with the zoning code, but there was some action by the township that led him to believe that he could move forward. So each of the three theories, whether it's a vested right in the permit, variance by estoppel, or equitable estoppel, which is equitable estoppel is more of the legal theory that you're affirmatively telling, you're not necessarily overturning the enforcement as you're telling them that they can enforce it. Basically, that they have to let him do what he wants to do, right? And so those three theories are intertwined, and they each have an element of good faith on the part of the developer. And that, again, is always going to be your key inquiry. Your second key inquiry is what action or acquiescence by the municipality occurred that led the developer here to believe that he was fully compliant with the zoning code. And, you know, as I don't want to go through it ad nauseum, but, you know, he, as I've said before, he relied on his architects. They're the experts. They drafted plans. We submitted them to the township. We paid the township to have their own engineers do a zoning review, and they even missed it.
All right.
So, I mean, that's the
Okay,
his crux.
so what the township has cited regarding Shuey is, I'll just read what's written here. A landowner is not permitted to quietly embrace a mistakenly issued permit.
Well,
In what way did Mr. Brasso not quietly embrace?
Because he didn't know at the point of the time when the permits were issued that they were in violation of the zoning code. There's no testimony in the record where David said, "Hey, Mike, you know what? We're gonna swing this in. We're gonna under the radar. We're gonna get this done." What he did is it was, you know, plain as day on the plan, which I don't know if it's still here, but the dimensions are plain as day on this drawing here. That, you know, they did their height calculation based upon the general standard, which is, I think it was 280.4.
So let me
Right.
refine my question a little bit more then. In what way did Mr. Brasso not blindly rely on the permit? I'm just reading the language as it's quoted.
So you're on.
I'm on page 3 of the township's brief. Having been aware of the requirements, it was their duty, the "their" refers to the landowner, to abide by such requirements. Well, I'll back up. Notwithstanding whose burden it was to realize that their pool did not fulfill the requirements, landowners cannot blindly rely on the permit and claim good faith.
Well, I would cite to page 20 of my brief, which I do rely on Petrosky, and where I say, indeed, a vested right and a permit issued in error must be found where the applicant made a good faith effort to research the applicable zoning code. And this is a quote from the case. We reject the notion that a citizen who does attempt to check the zoning statutes by making inquiry of the proper officials, who certainly should be expected to have knowledge about zoning, has not exercised due diligence. So again, we come back to, he paid the township for their own review. Their own engineers said you're zoning compliant, and they issued the building permits.
Well, I think the issue, I mean, Shuey has to do with good faith. So the landowner gets a permit issued in error and discovers it soon enough, or is aware of it, or isn't told about it, whether there's a formal violation or not, then that landowner has some obligation to stop what they're doing. They can't just keep building. That's why I asked questions about why did you keep building. So he was told in February by Mr. Kachansky, he went to a meeting in Bryn Rose with the residents and said, I know I have a problem. I think he said that. I think the minutes that have been marked would say that. And then in early March, you have his architect's handwritten notes where he said, I got a permit, I'm building, irregardless of the height problem. I don't know whether I would advise the client to do that. Maybe on an above-ground pool, such as Shuey, I would have, but not on a $695,000 building. I mean, so this is a little, Shuey's a little different, but I don't think a landowner who knows can lay in wait and basically increase their damages by continuing to build when they know, I mean, it's a serious height problem. It's not a couple inches, it's not 2 feet. It's way over what the requirements are. So I think there's a matter of degree here, and above-ground pool versus this is a little bit different also.
So, okay, so to that end, my concern in this case is the good faith element, of course, and the fact that notice was made in late February and then building continues to proceed. So even though I seconded the motion, I do have reservations about whether or not there was a true good faith and a true innocence to the developer's conduct in this case.
In terms of the Petrowski test, I don't think that there's any question, I don't have any question regarding the substantial unrecoverable funds prong. Obviously, the appeal period expired. I think it's a combination in my mind of the due diligence prong and also the good faith. There's a question about what the landowner did in terms of due diligence, and I think essentially the testimony is that he deferred to his professionals. And then the question is what the professionals did and whether it constitutes sort of due diligence given the entirety of the circumstances. And it's a really unfortunate circumstance, but my conclusion would be that it does not. And in terms of good faith, there's as I tried to address in my questions, the issue about proceeding beyond the late February date, and then the sentence I was looking for without success in the enforcement notice is a sentence that says you're advised to cease all construction activities until this matter is resolved. And I'm sure the applicant will say that, advice is different than a formal cease and desist. But again, there's affirmative direction / request from the township to take certain action, which was not taken. I think it's a substantial nonconformity, and it's an unfortunate set of circumstances. But given the entirety of the circumstances, I will not support the motion that's pending.
So if we assume that Petrowski is the case where, and both parties have mentioned that case, so that's what I'm focusing on here. And based on the evidence we heard tonight, at least in my opinion, I think the equitable factors are strongly in favor of the applicant. And I'm just going to go down this list. The first is the party's due diligence in attempting to comply with the law. Now, there's no question about it. He hired professionals to make this determination for him. They came up with a conclusion as to how you measure a building for purposes of these rules. We also have a firm that was hired by the township, Keystone, who came up with the exact same conclusion. There's a third party, Yerkes, who also came up with the exact same conclusion. The township came up with the same conclusion. So that's the testimony that we heard tonight. So you have a situation where you have third-party professionals who have come to a conclusion, and they make their advice based on a conclusion. I don't see how that is not exercising reasonable due diligence. He hired professionals to look at these issues for him. Ultimately, he's the owner. He should have known. The township should have known, but neither of them did. That's what we're dealing with here. And that's the testimony. They did not know they were violating any type of ordinance here, and that's the testimony we heard. The next factor is expiration without appeal of the period. Well, it was beyond the appeal period, so that is not relevant here. Sufficiency of evidence to prove that individual property rights or the public health, safety, or welfare would be adversely affected by the use of the permit. Well, we heard no evidence whatsoever that this is 5 foot added to a roof is going to affect the public health. I didn't hear any evidence of that tonight. So that's the third factor. The party's good faith throughout the proceedings, and this is, I think, the subject matter of your concern. We have the owner who got a notice from the township in February that there was an issue with the height of the building. The testimony was he reached out to his professionals, and there was a difference of opinion there. And, you know, I'm a tax attorney. I represent taxpayers. When I get a notice from the IRS, I don't tell them, well, pay it, because they're right. You know, you got an opportunity to appeal these types of notices, and that's why we're here tonight. And to just say, okay, you should stop construction, well, in the real world, that is very difficult. You have contractors under contract, you have subcontractors under schedules, you have completion dates, you have an outside completion date where you're going to be in default of your loans. There's a lot of difficult issues with just stopping construction, along with the safety of the property. So that is not just an easy decision that someone can make because another party believes they have violated an ordinance. And I don't think the owner had any obligation whatsoever in this case to stop construction. If the township really felt that way, they would have stopped it. That didn't happen. So you can argue the township did not act in good faith. If they really thought that this was an issue, they would have stopped construction. That didn't happen. So the final factor, the party's expenditure of substantial unincurable funds. The testimony is that to meet take 5 foot off that building is impossible without tearing the building down and starting from scratch. That's the testimony. The testimony was for hard costs, I believe that he mentioned $250,000, and in my book, that's substantial, and that would be lost. So I think we meet that factor. So again, I think all 5 factors were met. All the parties made the same mistake here, and I think for the township to come back at this late point after the building's been built and say take the roof off is not equitable. That's where I'm at.
This, has been described as a bit of a series of unfortunate errors, and that's been borne out this evening. And when there's, at least to my mind, not compelling evidence in one direction or another that a party was intentionally taking inappropriate actions with respect to the construction of this property, the development of this property. I think we are compelled to consider the equitable issues that are at hand. I would note, just for the record, that there's there's no dimensional variance here, there's no hardship here. That's not what we're talking about. We are in the murky world of these equitable cases, which, the treatises in this area tell you come up once, not all that often. And I guess this was the first one I've seen since I've been on the board for 5 years, and I think it's similar for everybody else. I view this as a Petrosky case as well. I mean, it just is. I view the facts a little differently, perhaps, than others. I'm not certain that the applicant has satisfied the due diligence portion of this of the Petrosky test, and I say that mindful of the fact that other professionals that were working for the township also screwed up it's not simple reading of the zoning code, but just read the zoning code. It's in there, everybody. And to rely on professionals to do that is completely acceptable. And, unfortunately, in this instance, the professional, I do not think, conducted the sufficient due diligence that would be expected of a professional to get the right answer in terms of how you measure building height. So I don't know that the prong of due diligence under Petrosky has been satisfied. Substantial unrecoverable funds, I think, has to be viewed in context. And this is where continuing work after the February indication that there was an issue runs the applicant a bit off the tracks. Reasonable minds can differ as to what the next right step was. I kind of would have measured the building to see how high it was, and then identify how it was that it was 36.9 feet, or depending on who's measuring, because we have different numbers. It's too tall. Everybody agrees it's too tall, but taking that as a given. Certainly, I think the applicant could have mitigated its damages with respect to continuing work after the February indication that there was a height issue. Appeal, as George points out, that's not an issue. Injury to the public, health, safety, welfare. I am mindful of the extensive work that a lot of people went to put the special zoning code together for the Garrett Hill district, and I'm not disregarding that when I say that in this circumstance, if the building were to remain as it is currently constructed, that there would be no damage to the health, safety, or welfare of the community. It's taller than it should be, and that was a focus in developing the zoning district. But there's I'm not convinced that there is a good fix here, because even if they cut 2 feet off, I'm not sure that it still wouldn't be compliant. So, we're in the world of equity. We're in the world of trying to make sense of what makes sense for everybody, does the least damage for everyone, satisfies the township's rightful interest in enforcing its zoning codes, but also acknowledging the fact that the applicant, to some extent, may have certainly proceeded on construction after the issuance of the permit, thinking that all was well. So you'll note, and I noted as I went down this list, that I'm firmly on both sides of this issue, which makes it rather a challenge. But then you have to weigh all of the equities involved. And I don't know that there has been a sufficient enough showing, that there was not, that parties acted in bad faith to overturn the enforcement action and force a remedy that doesn't make a whole lot of sense, economic or otherwise, for the parties involved. So at this point, what's the motion again that I'm?
We're going to accept the challenge to
Yeah, okay.
enforcement.
So I am inclined to vote in favor of the motion. Welcome to the board, Jamie.
Got it. Thank you. I won't restate much of what was said. And my apologies. I won't restate much of what was said, but where I'm stuck is on number 4 and number 5 of Petrosky. Had the wording in this case said until February, I might be in agreement of things met here, but I think there was a wonderful opportunity to put the brakes on and start measuring with immediate concern as a developer with an $800,000 loan that is, you testified, personally guaranteed. It's a lot of money and has a lot of risk. And based on what we heard here tonight, it sounds as if you're very serious about your development, if I'm correct. So I'm not sure I agree that the parties acted in good faith after February. I believe up to February, when you were not aware of the mistakes in the permits, I can agree to that. And so I agree with John that I think both sides have issues here. And how do you fix something that's already been built? It sounds like a terrifically large and expensive job to do so. But I'm stuck on the access you had to the administration, access you had to the neighborhood, access you have to, a tremendous number of experts to be called in to find out more information. And if this is what you do for a living, to become the utmost expert on this problem, as opposed to continuing. Because we get better as we learn, and we face these challenges. So I'm stuck there, and based on everything we heard here tonight, I'm not sure how that's forgiven, in that the continuing to build is why your costs, continue to increase. So I don't believe you met number 4. That's my opinion.
Is there any other discussion of the board?
Well, I would say, that you're right, there's equitable factors here. And, the harm on one party is if they're going to comply, they have to tear the building down. The harm on the other side is neighbors have to live with a building that's 5 feet higher. So I think you have to weigh those equities.
I want to make a unorthodox suggestion. Yeah, I want to make an unorthodox suggestion, which is that we consider tabling our determination till the September meeting. I think we've left significant doubt in the parties' minds where this is going to turn out, and it might serve to force them to achieve a settlement. That's my suggestion.
An unorthodox one it is. Any thoughts on that? And what would happen is, in essence, we would continue the hearing until the 19th of September. I believe that's.
No more testimony?
No more testimony. We just, I mean.
To make that clear.
Well, we have, don't we have 45 days?
Or would you waive that? Because if not, then we can continue the hearing. Because if we continue the hearing, then it would be, the hearing continued with the possibility of more people testifying. then we'd have 45 days after the continuance, correct?
Right, well, if you take testimony. If you just continue it and vote and don't take testimony, I've done it. I've litigated that one.
I know.
It's the last hearing. It's not the last time you have an oral argument. So, yeah, I think you have 45 days from tonight if the testimony's and the record's closed to make a decision. So,
Yeah.
which I'm fine with that.
That's what I had intended.
And then,
Yeah.
Will everyone be, all five of us have to be here on the 19th of September? I mean, anybody need to check schedules? No? Okay.
And just so that'll be further discussion and then a vote.
That is correct.
Personally, I would like to deliver the message that if you don't reach a settlement by September 19th, we're going to vote on it. I don't know how the vote's going to turn out. I can't imagine you two know how the vote's going to turn out. So don't pull a Villanova Lights thing. It shouldn't take 9 months, okay? I mean,
That's a sore point with Mr. Martin.
it should, you know,
well, we have to issue a decision in 45 days.
right.
45 days from tonight.
Right, so, I mean, again, my suggestion is, and if we're going to proceed, the motion has to be withdrawn, a new motion has to be made. But my point is, neither party should think you're going to come in here and say, we're still working on things, what do you,
No,
you know, just.
we tried working on it, so.
Try to work it.
We'll try again.
Okay, so at this point, George, would you withdraw your motion at this point? So,
I think I have to, because we're going to vote on it.
I think you can table it. I mean, if there's a motion to
well,
table.
motion to table consideration.
Right.
Yeah.
I'll entertain a motion to table further discussion on Mr. Nagel's motion at this time and to reconvene on the 19th of September. Would someone like to make that motion?
Yes, I would make a motion that we table Mr. Nagel's motion and consider it without fail on the meeting on the 19th of September.
Is there a second?
I'll second.
Call the vote. All in favor of the motion to table, please indicate by saying aye.
Aye.
All opposed? None. So that motion is tabled. There's no other business before us this evening. Thank you very much.